Morning, everyone.
Good morning.
Morning.
Morning, Your Honor.
Good
Good morning.
morning. Ready to start?
Yes, ma'am.
Good morning, Judge. The ACDC requested to go first with position 7 and 8, if that's possible.
Okay. All right, this is our state all-purpose calendar for Tuesday, September the 12th. I'm Judge Regina Mincy. Just want to remind everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. So listen to your attorneys and govern yourselves accordingly. All right, position 7. Jerry Lee Campbell.
Yes.
That is 23 CR 005-222H. Charge at 1 count of criminal trespass, a 2nd count of willful obstruction of a law enforcement officer. This is going to be a plea.
Is it a plea or a bond hearing, Your Honor?
Your Honor, if this is position 7, this will be a bond hearing. My apologies. We're in courtroom 2 with position 7. I thought we were handling ACDC first.
Yeah, she made the announcement that it was position 7 and 8. I'm not quite sure what position it is.
Must not be.
There's position 10 and 11, or excuse me, 11 and 12, Ms. Douglas. That's at ACDC. I know that. I'm not sure if this is Ms. Douglas.
That is ACDC.
Ms. Douglas, is that you in ACDC?
No, it's Miss Wawaru.
What's your name?
Miss Wawaru, Miss Margaret Wawaru.
My client.
Well, why would they have?
Do we? That's me for. Nope, not there.
Oh, it's Margaret. Well,
Can't understand what she's saying.
Miss Margaret Wawaru.
I think she's on probation, revocation number 7.
Yeah, she's probation, Your Honor.
Okay.
Ask her.
I didn't know, Your Honor.
All right, I don't have a probation revocation of 7 and 8. Mine stops at 6.
Yes, you number 5-6, Your Honor.
Just number.
Oh, I think she might be 5 and 6, Your Honor, maybe.
There was an updated one that was sent out later. I can,
Yeah, she's
let me know,
7
I
and
can
8.
send it out. Yeah, because there is a probation revocation that has actually 10 people on it.
Mhm.
10.
Yeah.
And this is Officer Milton at ACDC. Do you have a Vasquez on the calendar? What's your first name? Alana Vasquez.
We do.
Okay, she's here also. I have her here.
Milton,
That's 47 of Vasquez.
Your
I
Honor,
just want to know. Thank you.
Milton,
Yes,
Yeah.
sir.
Sergeant Johnson wants us to do Cobb County first,
Uh-huh.
next, then we can go to you, but it has to go in that order.
No
Because,
problem.
okay, thank you. So we're going
Uh-huh.
to county first, Your Honor? Come on.
Good morning, Your Honor. Mr. McLean here for the Public Defender. Position 30, Mr. Moss, the person from who's being held in the Cobb County Jail. We had announced that as TVA in order to meet him and discuss the case. We have done so, and he is a negotiated plea this morning, Your Honor. So we're ready to go forward now.
All right, let me get straight here because I'm very confused at the moment. We're doing position 30,
Correct. That's
James Moses,
Moss.
Moss. Okay, I'm sorry, James Moss. And
Correct.
this is the plea, is that correct?
It is.
All right. And then let me look for that other probation calendar.
Your Honor, I just emailed it to you.
Thank you. All right, this is 23 CR 0036445D. Mr. Moss is charged with 1 count of fare evasion, 2nd count willful obstruction, a law enforcement officer, and criminal trespass. State.
Yes, Your Honor. For count 1, the state is asking for 12 months probated, balance suspended. Count 2, 12 months probated, balance suspended, a $300 fine. Op 21. For count 3, 12 months, served 90 days, credit for time served 71 days, balance suspended, stay away from MARTA property and comply with any and all active MARTA suspensions. To my understanding, the defendant is suspended from MARTA until November 1st.
All right.
I apologize, Judge Nancy. Before you, is this a balance suspended or a balance probated?
Suspended.
Would a With a $300 fine?
Then he
Mhm.
can't be suspended.
Can't be, oh, sorry.
Go ahead, Casey. You got it.
No, I was, that's why I wanted, because she said balance probated first, and then she said balance suspended, but it has a fine, so I just want to make sure that I'm putting it correctly on the Senate sheet.
We could
I
take the fine
apologize,
out.
Judge Missy.
We could remove the fine.
Remove the fine and make it suspended.
Yes, Your Honor.
Okay.
One other question I would have, Your Honor, is I noticed that Operation 21, which is a giver of classes, was mentioned, and I wasn't sure why that was mentioned in the offer.
Because then we'd have to go back to probate it because he'd have to have time to complete the program, correct?
Right, so that might have been just inadvertent, and it might not be a problem at all.
I don't know. You tell me, State, what is Operation 21?
So we're going to keep it balance suspended and get rid of Op 21.
Very good. So
Okay.
I understand everything's balance suspended, and he is certainly in agreement with that.
I bet. Okay.
Right.
All right, Mr. Moss, are you ready to take your plea?
Yes, ma'am.
All right, I'm going to ask you a series of questions to make sure that your plea is free and voluntarily and you understand what you're doing today, okay?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and the first question I'm going to ask, are you under the influence of any unprescribed medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
And has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked or affected by this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, so as to all three charges, you plead guilty, is that correct?
Yes, ma'am.
All right, and I will accept that guilty plea. Again, that's 12 months probation, balance suspended. And credit for time served 90, credit for time served at 71. Stay away from all MARTA. You cannot get on MARTA. Your suspension goes through November the 1st. All right.
Yes, ma'am.
All right.
Thank you.
Thank you. Mhm.
Thank you, Your Honor. That concludes that matter.
Okay.
Position 44, Mr. Tate. Let's switch seats. Sir.
Come on.
All right. This is 23 CR 00408-1J, Jonathan Tate, charged at 1 count of simple battery family violence. State.
Your Honor, my client is going to be, this is Charles Ford on behalf of Mr. Jonathan Tate. My client will be pleading not guilty at this time, and we will not be having a bond hearing.
All right, where, oh, okay, there you go. I didn't see you there. I apologize, Mr. Webb. How are you?
Mr. Ford,
I'm sorry, Mr. Ford.
that's okay. Okay.
All right. So does he need to be formally arraigned?
That I do not know, Your Honor. I'd have to ask the state on that.
Do we know or have any information, or I will just arraign him? Or a bond hearing?
No, we're not gonna have a bond hearing, Your Honor, and we'll waive formal reading of the of the arraignment. Well, of the
All right,
accusation.
since you're going to waive formal reading, just to let Mr. Tate know, with this charge of simple battery, family violence, that you've been charged with, and formally accused by the Solicitor General's office here in Fulton County. And I just want you to know again that this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. For this charge, the case will be reset for jury trial. That trial will be scheduled by the division judge to whom this case is assigned, and further notice for trial. Make sure you have your address current with your attorney and everything so that you will get notice of your trial date. And I accept your plea of not guilty.
It's good. Thank you. This case is already good.
Your Honor, position number 17,
Okay.
Mr. Glover.
17. This is Ashton Glover.
That's correct.
Yes, sir.
All right, 23 CR 0052117A. Mr. Glover is charged with 1 count of simple battery, family violence, and a 2nd count of criminal trespass. State.
Yes, Your Honor, I have that this just will be an arraignment this morning and reset to jail jury, I believe.
That is correct. It's a not guilty. We waived any formal reading of the accusation, Your Honor. In his situation with bond, we believe it is moot at this time, so we will not be making a bond request because of another case with a very large bond.
All right. And so, Mr. Glover, with the 2 charges that I've just read, you've been formally accused by the Solicitor General's office here in Fulton County, to let you know that each of those charges carries a maximum sentence of a 1 year in jail and a maximum fine of $1,000 for each of those charges. This case will be reset to a jury trial. Trial will be scheduled by the division judge to whom the case is assigned, and you will have further notice for trial. Keep your address current so that your attorney and everyone else will get the notice. And again, your case will be further notice for trial.
And while he's on Zoom, Your Honor, let me assure him that I will make a note to someone in our office that on that 17 CR case, we get somebody to look into that for you. Thank you.
Okay, someone will do that. All right.
Can I go ahead and ask a question?
I can answer any question you've got, but I'd rather do that in private.
Okay, the only reason why is because,
Sir, I'd
Okay.
rather do that in private. We're in public right now.
This is being recorded and live streamed in Zoom, so you need to be careful. Listen to your attorney.
After I turn in my paperwork today, I can come by and do another visit to the visitation booth and answer any question you've got. I'll make a note of that. Mrs. Glover, thank you.
Position number 13, Mr. Everett.
This is 23 CR 0052118Y. Dennis Everett, charged with 1 count of simple assault, 2nd count public drunk. State.
yes, Your Honor, the state's recommendation is going to be a modified offer. It's going to be 12 months to serve, 34 days, credit for time served, 17 days, balance probated, with the conditions of an 8-week anger management course, no further contact with the victim, Jada White, and a stay away from the incident location. I can give that location to the court in just a few seconds.
Okay.
That address is,
Your computer will be forced to shut down. Your Honor, not to interrupt, we just got a notice saying the courtroom 2 computer might reboot in 15 seconds, so if we go out.
Okay,
it actually happened at MARTA, so I would just ask that he remains compliant with any MARTA suspensions.
oh, Marta, okay.
That's if there are any suspensions, that's all.
I don't know.
Yeah, I think they're,
I had my laptop as backup. Our computer, courtroom 2 computer did just go down. My apologies, ASG Walker, could you repeat what you last said?
Just to remain compliant if there are any active MARTA suspensions.
Right, and Mr. Everett is clear on the suspensions that are in place, so this will be a negotiated plea, and we do stipulate to the factual basis, venue, and ID.
all right,
My computer went down.
right. And is that Mr. Everett? Okay, 4 South, okay. You can hear me, Mr. Everett? All right, good. I understand that you want to plead guilty. Is that correct?
Yes, ma'am.
All right, I'm going to ask you a series of questions. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, first question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
You're giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
And you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Fluctuating.
Did you hear me there?
Yes.
I'm getting some feedback. Someone else is talking and I can hear you. Okay. All right. Are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're presently on probation, your probation could be affected by your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right. And so you understand your conditions, which are to, your sentence is going to be probated in order to give you time to complete the 8-week anger management course, to have no further contact with Jada White, and to stay away from MARTA or comply with any and all suspensions. All right.
Yes, ma'am.
All right. Good luck to you.
Your Honor, we would request probation to switch to non-reporting status upon completion of the anger management, and if this court could waive any of Mr. Everett's probation fees to help him get back on his feet.
I'll if the state doesn't have any huge objection, I'll let him go non-reporting after he completes his anger management.
No objection, Your Honor.
All right. Yeah, I'm not able to waive any fees at this time.
Thank you, Your Honor.
All right, thank you.
Yeah, position number 33, Ms. Phillips.
33?
Yes, ma'am.
All right, this is 23 CR 005238Y. Devonta Phillips, charged with 1 count of simple assault, family violence. What are we doing here?
Yeah, this is a bond hearing.
All right. State.
Yes, Your Honor. Bond is currently at 5,000 cash bond. This incident happened August 29th of this year at 2470 Camula Lane, Northeast Atlanta. Officers came to the location due to the property manager sending an email out concerning someone impersonating a security officer, and it sounded like a person was in dispute with a Black female, which we found out was Miss Valencia Watson, which is the defendant's girlfriend, mother of his children, and the woman was holding an infant, and that's when she advised officers that he had threatened her and pulled out a knife, and that she'd been trying to leave the area. She advised officers that the incident had originally started at the gas station, and then defendant became irate due to an argument, which turned aggressive, and he was holding a pocket knife. And once they arrived back at the mentioned location, that's when he stabbed her tires and threatened to stab her and making her feel safe. And a nearby witness, which was a neighbor, noticed it and called and heard the dispute and advised officers. Additionally, Your Honor, defendant is violent, and defendant has many battery, not convictions, but battery cases involving the same victim. In addition, at his bond hearing, the victim was able to speak, and she is afraid of him and doesn't want contact with him. And also considering that, when he was given the $5,000 cash bond, Your Honor, it took 3 officers to get him to calm down during court. So the state believes that the $5,000 cash bond is more than reasonable.
When was that? Do we know?
It was probably like the 30th. It was my case, so I remember specifically. But he became irate when Judge Morrow gave him the bond, and it took 3 officers to pull him off camera. And just, he currently has a simple battery from 2020 guilty plea with the same victim. He has a 2021 guilty plea battery, 4 counts of cruelty to children, 2022 battery family violence from Clayton, same victim. Your Honor, $5,000 is more than reasonable for this defendant.
All right, I will continue with the $5,000 cash bond.
Your Honor, can we make argument on this?
Oh, I'm sorry.
Or either this or this. Can't be.
I apologize. Go ahead, Mr. Ford. I sincerely apologize.
Oh, that's okay, Your Honor.
The solicitor wants to make light of the fact that it was carried away by 3 officers when a $5,000 cash bond was given, not giving my client opportunity to get out of jail on a decent on a bond. I think that should be less than $5,000 cash. My client is a high school graduate. He works for the No Limit Security. He has 4 children that he's financially trying to help support. He has a stable address, and yes, he's a lifetime resident of the state of Georgia, so he's not going anywhere, Your Honor. So he's not at risk of flight. Like I said, he had a permanent address, I have an email address for him. He has community support. He's given me the telephone number of his mother. He has a hold in another county, Your Honor, so I think he should be given an opportunity to bond out so he could actually go ahead and take care of the business in the other county. We're asking, Your Honor, that it be a $1,000 surety bond, that the cash bond be reduced to a $1,000 surety bond, Your Honor, so my client would have an opportunity to deal with some of the issues. This is only simple battery, Your Honor. There's no evidence of any type of harm as far as marks. This could be just a simple pushing of an individual. So at this point, Your Honor, we're asking for a $1,000 bond, surety bond at this time, not to remove the $5,000 cash bond, so we can deal with the other issue in the foreign county.
Okay.
Your Honor, I just want to put it on record that this man is an extremely dangerous individual, and he's dangerous to the victim. He currently has 3 open cases, family violence, battery family violence, criminal trespass, and this case, and the risk of reoffending, considering 4 cases within the past 2 years concerning the same victim. Although it's simple battery, Your Honor, there have been cases where that the the injuries have been worse, and I don't believe that we should wait until the injuries are lethal. The state stands at the 5,000 cash bond.
Yeah, Your Honor, and just in response, I believe the solicitor is trying to look into some crystal ball that doesn't exist. This is simple battery, Your Honor. That's all the charge. This is the allegation at this point. And my client is pleading not guilty. He wants to come back and make sure that he defends himself in this matter. As also the solicitor mentioned, there were some cases that he was charged with that were not pled guilty or he was found guilty, Your Honor. So we're asking if the cash bond should be reduced to a $1,000 surety bond, Your Honor, this time.
And Your Honor, if allowed, if a pretrial can read his history so he can get a better outlook of his history, Your Honor, because I'm understanding Mr. Ford, however, his history does sing a different tune than what Mr. Ford is saying, Your Honor.
So, Mr. Ford, does he have the 3 open cases and the prior cases with the same victim?
Your Honor, I'll definitely defer to the state if they're saying that, Your Honor.
No.
And my client is saying no to that. He has his hand up and maybe he can give better clarity to those cases than I can. But
I usually don't take that information from the defendant, but I see pretrial is here.
Your Honor,
Hold on a
Yes, Your
second.
Honor, I am here.
All right. You have the history on this defendant?
Yes, I do.
Okay.
Defendant has 33 cycles in Georgia, beginning in 2012. He has a misdemeanor conviction out of Fulton County for criminal trespass. That's from September 2015. He has another misdemeanor conviction out of Fulton County for battery family violence. That's March of 2016. We have another misdemeanor conviction for criminal trespass, willful obstruction, and simple battery. That's February of 2017. You have another felony conviction for false imprisonment, battery against a female who is pregnant, cruelty to children in the third, and possession of cocaine. That was out of Cobb County. He received first offender treatment on that case, and it was revoked February of 2022, and he was given 10 years probation on that case. So he's still on probation. And we have another misdemeanor conviction out of Gwinnett County for driving while license suspended. That's from April of 2019. He has 5 violations of probation, 3 FTAs. Last arrest was June 2023 at Georgia Tech by Georgia Tech Police Department. That was for a criminal trespass. And he does have a hold for Cobb County for a misdemeanor probation violation. That warrant was signed August 2nd, 2023. Nothing to add, Your Honor.
All right.
Your Honor, and as you can see, I'm looking at 3 offenses that are 2015, 16, and 17, more than 7 years ago, Your Honor, and those should not be held against the client at this time, Your Honor. He needs to deal with the hold that's in Cobb County because that was an FTA. I think the $1,000 surety bond would be appropriate so he can at least make bond, Your Honor, and deal with the case in Cobb County as well.
And Your Honor, I can provide the recent cases in Fulton County. Partial of the reason for the 5,000 cash bond that Judge Morrow struck down was because upon a plea agreement, the defendant was advised not to have no further contact with the victim, which is Ms. Valencia Watson. And because he did not follow that, that's why the cash bond was put in place specifically. But the simple battery that I think Judge Morrow did, 20 CR 004-165F. The other one is 21 SC 178-123. That was from 2021. And then the other one in Clayton is 2022 CR 00065. That's in the past year and a half.
And those are not convictions, am I correct?
No, those are convictions, Your Honor.
But those are with the same victim?
Yes, Your Honor.
That's my concern. Mr. Ford is the same victim. And whether they're simple battery or a regular battery, I understand your point to that, but it still seems that we're having several cases, repeated cases with the same victim
Your Honor,
when there's been stayaways.
yeah, my client has no problem with the no further contact and stay away from the alleged victim's address, Your Honor. I've spoken with him and he has no concern with it. I'm making contact.
Well, again, I'm inclined to continue with the cash bond or very, very high surety bond. And I understand he has the hold from Cobb, but I am concerned about his history and the repeated offenses, whether minor or major, against the same victim. And maybe he's ready to stop after the third or fourth case, but that says to me that he does not respect those orders and did not follow those bond conditions in the past, with considering the FTAs as well. And so, I'm inclined to do a very, very high surety bond if I'm going to change anything, but I'm not impressed with what I've heard to make me change Judge Morrow's order with the 5,000 cash.
Your Honor, could we ask what that surety bond would be?
Probably a 20,000 surety.
Yeah, Your Honor, because that would at least give them an opportunity to bond out. Your Honor, the $5,000 cash bond, he has no opportunity at all.
All right, I will change it to a $20,000 surety
But
bond.
I was gonna ask if we could make that 10,000, Your Honor.
Nah, I'm gonna leave it at 20,000.
All right, Your Honor.
All right, I will change it to a 20,000 surety bond. All the same conditions to stay away, no further contact with Ms. Watson and her minor children. All right, your client has a question, I think.
Mr. Phillips, unless there's something specific about the process, Your Honor, I would ask that you not speak at this time. Your Honor, I'll leave that up to you if you'd like to hear from the
Okay,
defendant.
2 seconds.
I wanted to answer a plea today.
That's something you definitely need to talk to your attorney about.
Let me see what. I'll have to speak with him, Your Honor, about, because he.
Yeah, I
when he first
understand.
spoke with him, he did not want to enter a plea, so at this point, I'll have to speak with him about the offer,
Okay,
all right?
all right.
I'll hold him to the end, Your Honor.
Yeah, your attorney will get to you in a second.
Yeah, I'll come see you, Mr. Phillips. Is he here? Did I see him? Can I look? Unless you want to do a breakout session, I would like to go see him. He's upstairs. Do a breakout with your laptop. I can do a breakout, Your Honor. No. Your Honor, the officer will allow me to do a breakout session with Mr. Phillips, so we should come back. We'll be back with the plea.
Okay,
All right.
all right, thank you.
I do have a quick announcement for South Annex. South Annex. You all can go ahead and go.
All right.
I have Miss,
Miss Milton, we're doing South Annex right now.
all right, call me when you're ready.
Thank you.
Your Honor, I have an announcement for the court.
Okay,
On the Zoom, in the gallery view that I'm looking at, on the one that's marked South Annex only and not ACDC South Annex 2,
mm-hmm,
I have one client I need a breakout with, and his name is McKinnon. We were not able to interview him yesterday. So I need to break out with McKinnon.
all right, that's position 27. Is that Jimmy McKinnon?
Correct.
Or if you want me to call him.
All right, Ms. Strong, are we able to do that?
Where is the defendant located at? Is that him in South Annex now?
Right,
Yes.
the one that says only South Annex and not the.
Okay.
And
That is all right.
if that breakout room could be with PD Angelo Dovis so that Attorney McLean can step into another room.
Okay,
Very good, thank you.
thank you.
I do have another announcement for 4 South. Ms. Blunt.
Yes,
Hey, Ms. Blunt. For Abernathy Richard, he was on 2 North. He got moved to 4 South, 400.
All right.
Next, we'll do position number 3, Mr. Ashton.
all right, and where's Mr. Ashton? Which one is he? 4 South?
Courtroom 2.
Oh, courtroom 2, okay. All right, 23 CR 005235A. Robert Ashton, charged at 1 count of DUI. Second count, possession of open alcohol container. Third count, willful obstruction of a law enforcement officer. State.
Yes, Your Honor, the state's recommendation is 12 months to serve 32 days, credit for time served 16 days, balance probated with the conditions of a $600 fine, alcohol and drug evaluation with any necessary treatment, a risk reduction course, 40 hours community service, and 1 victim impact panel.
All right, Mr. Dodas.
Yes, Your Honor, I went over all of this with Mr. Ashton, and we are prepared to go forward with a negotiated plea and would stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right, and Mr. Ashton, you wish to plead guilty today?
Yes, Your Honor.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, and I'm going to ask you a series of questions. The first one being, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Your Honor.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
You've given up and waiving the right to trial by judge or jury, whichever you prefer.
Yes, Your Honor.
And you are prepared and agree to waive these rights today?
Yes, Your Honor.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're presently on probation, your probation may be affected by your guilty plea here today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
And you understand your conditions, is that correct, for probation?
Yes,
You've got a $600 fine, and alcohol, drugs, evaluation and treatment, risk reduction, 40 hours community service, and 1 victim impact panel.
Yes, Your Honor.
Okay, and so if that is the case, and you understand that, I will accept your guilty plea.
Thank you, Your Honor.
All right, thank you.
And Your Honor, we would request this probation to switch to non-reporting status upon completion. And if the court could help waive some of Mr. Ashton's probation fees. Upon release, Mr. Ashton is headed to the Mariposa Sober Living Community. He'll need time to get back on his feet. He knows what's required of him. We just want to make sure that he has that cushion if possible.
All right, I will waive 6 months of his probation fees.
Thank you, Your Honor.
All right,
And Could we go non-reporting upon completion of all these conditions, Your Honor?
Yes.
Thank you, Your Honor.
Uh-huh.
Position number 23.
What position? Position 23 is going to be Attorney McLean. He might still be in a breakout room.
Position number 4 and 5, Mr. Barry.
All right. This is. I don't have a case number, state.
I
On
have
the
it, Your
calendar.
Honor.
Okay.
I believe I have it. Let me check. 1 second.
I have it if needed.
So for position 4, it's gonna be 19 CR 001320A. He's charged with battery family violence.
All right.
Um,
And this is going to be a plea?
that is my understanding. Would you like me to read the recommendation onto the record?
Okay, that is fine.
State's recommendation is 12 months to serve, 30 days, credit for time served, 15 days, balance probated with the conditions of FFIP, no further contact with the victim, William Moore, and a stay away. And I can give you that address. It is 1739 MLK Drive. It's my understanding defense is requesting a NOLO. Of course, the state is in opposition to that. I will request that pretrial read any history.
Right. Yes, Your Honor. We are clear on all conditions. Our only request is to enter a plea of NOLO.
Okay. All right, I would like to hear the history.
Defendant has 12 arrest cycles. He successfully completed a felony first offender case, November of 2020. History within 10 years. Let's see, it includes 2 violations of probation. He has 1 misdemeanor conviction for driving without a valid license. And he received first offender treatment on that case too, April of 2020, and it was sealed November of 2020. And he has 2 FTAs. Yes, 2 FTAs. His last arrest was an FTA also. Nothing to add, Your Honor.
All right, if he's not used his NOLO, then I guess I can accept the NOLO plea.
Thank you, Your Honor.
All right, Mr. Barry, are you ready to enter your plea?
Yes,
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, and you can put your hand down for me. Are you presently under the influence of any medication, drugs, or alcohol?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
That you're giving up or waiving the right, I'm sorry, that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And you are prepared and agree to waive these rights today?
Yes, Your Honor.
And has anyone told you you receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And you understand that if you're currently on probation, your probation could be affected or revoked by this guilty plea today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
All right. And I will accept your NOLO guilty plea. And you understand the conditions. Balance probate, you have to do a FVIP, no further contact and a stay away from the victim. All right.
Thank you, Your Honor. We would request, Mr. Berry is clear on the 24-week FVIP program. We would request that probation switch to non-reporting status upon completion. Due to the 15 days in custody, as well as Mr. Berry tells me he doesn't have a stable job waiting for him, we would also request this court to waive some of his probation fees to allow him to get back on his feet and meet his financial burden by paying for these classes.
Right. I am not prepared to waive any fees, but he can go non-reporting once he's completed the conditions of FDIP.
Thank you, Your Honor.
Mhm.
Got that sheet I gave you yesterday?
Position 38 and 39, Mr. Sims.
38 and 39? I got those. Yeah.
Yes.
And this is going to be a negotiated plea, Your Honor.
Okay.
Good morning, Your Honor.
Good morning. All right, this is 20 CR 006196J, Kenneth Sims, is that correct?
Yes, ma'am.
Okay, and you're charged with 1 count of battery substantial physical harm, state?
Yes, Your Honor. The state is offering 12 months to serve 66 days, credit for time served 33 days, balance probated, 40 hours of community service, 8 weeks of anger management, no further contact with Mr. Robert Brady, and a stay away from 2280 Hamilton Road, apartment 307, Atlanta. And then we're going to no cross position 39.
All right. Is that your understanding, Mr. Dotis?
Yes, Your Honor, that is my understanding, and we do stipulate to the factual basis, venue, and ID. Our only request would be for probation to switch to non-reporting status upon completion of all conditions. Mr. Sims does have stable employment waiting for him, but he would ask for it to go non-reporting once he completes his obligations.
Okay. All right, I will do that. Mr. Sims, you ready to take your plea, sir?
Yes, Your Honor, I am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. And I'm going to ask you a series of questions. You can put your hand down. The first question being, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, Your Honor.
Do you, are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Your Honor.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
Are you prepared and agree to waive these rights today?
I'm sorry?
Are you prepared and agree to waive these rights today?
Yes,
by
ma'am.
pleading guilty, okay? Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has
No, Your Honor.
anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
All right, I will accept your guilty plea. And again, you've got your community service, 8 weeks anger management, no further contact with Robert Grady, and to stay away from that Campbellton Road address. Once you complete your 8 weeks of anger management, you can go now reporting.
So what is the reporting? Do I have to report the day that I leave here? Like, how does that work?
Yes, I believe he has, 24 hours to report to probation, I believe.
Your Honor, he does have another hold that will keep him. I'll go and speak with Mr. Sims so that he knows what's required of him upon release, but I'll give him information and including the address and telephone number to make an appointment.
Okay.
And Your Honor, it's 48 hours. I'm sorry, it's 48 hours upon
48
release.
hours? Okay. All right. They will
Okay.
give you that information, Mr. Sims.
Thank you, Your Honor.
All right, thank you. Good luck to you.
Thank you.
Position number 6, Mr. Biggers.
And Your Honor, position 6 will be a negotiated plea. We would ask to waive sounding of the charge.
Asked to do what? I'm sorry.
Waive sounding over Zoom of the charge. You could just
Oh, okay. All right.
You ready for the state's recommendation, Your Honor?
All right, 23 CR 0052225G, Jeffrey Biggers, charge at 1 count of PI.
Yes, the state's recommendation is gonna be 12 months to serve, 34 days, credit for time served, 17 days, balance probated with the conditions of a SDET course, a stay away from the incident location, which is 135 Edgewood Avenue, and it's omitted from the calendar, but we also will be requesting no further contact with Julian Garcia, who is the victim in this case.
All right, that's your understanding, Mr. McLean, yes, Mr. McLean.
Your Honor, this is my case.
Oh, Mr. Dotis.
That is my understanding. We would just ask you to switch to non-reporting status. And upon completion of the SDET, as well as waive all of Mr. Biggers' probation fees. He's currently residentially challenged and does not have stable employment. I provided him a list of resources and he's clear of what's required for him at Grady with the SDET. So we would request the court to waive his probation fees.
And due to the nature of the charges, the state will be objecting to non-reporting upon completion. It's requesting that he reports for the duration of his probation.
Okay. All right, Mr. Biggers, you're ready to take a plea? All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? All right, put your hand down for me. All right, are you presently under the influence of any unprescribed medication, drugs, or alcohol? Can you hear me?
No, Your Honor.
Okay. Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Right.
And that you're, okay, and that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
Giving up and waiving the right to presumption of innocence?
Yes, Your Honor.
And are you prepared and agree to waive these rights today?
Yes, Your Honor.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
And do you understand that if you're currently on probation, your probation could be affected by your guilty plea here today? Do you understand that?
Say it again.
Do you understand that if you're currently on probation, it may be affected by your guilty plea here today?
Yes, Your Honor.
All right, and again, you understand what your conditions are, and I will ask you, do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
All right, and so you've got some conditions here, and you've got to complete those while you're on probation. I'm not going to waive any fees, nor will I allow you to go non-reporting. I want you to report and do the full 12 months. Okay?
You say I have to do.
Well, I can go over everything off of Zoom, okay? Your Honor, Mr. Biggers might have a question. If I could please be placed on mute.
Okay.
Thank you.
Yeah, position number 24 and 25, Mr. Jones.
Thank you, Your Honor. I answered Mr. Bigger's questions. He's clear on what's required of him if we need anything further.
All right, thank you.
Oh, Mr. Biggers.
All right, we have 24 and 25, Elijah Jones, is that correct?
24, 25.
Yes, Your Honor, it is.
Elijah Jones? Yeah. That'll be Attorney McLean. He's stepping over.
Position 37, Mr. Rogers, Marquez Rogers.
Are we doing 24 and 25 first?
Yes, Your Honor.
Who do we have, Deputy?
Mr. Jones, Elijah Jones.
Don't speak, Mr. Jones.
Your Honor, that's an arraignment. He's not guilty.
Okay, Jones is not a plea.
That's correct. He's an arraignment. He's not guilty. We waive formal reading the accusation.
And there are two cases.
Yes, Your Honor. Let's see.
The first one, 22 CR 007338C.
And the second one is a different case number, Your Honor. It's a separate date.
Ending in 7340C 815.
Right.
The first one is 6/21/2020.
And so he's got an out-of-state hold, which he'll address. Bond is moot at this time, so we'd ask just to do a simple arraignment where I waive the formal reading of the accusation. We tell him that the court date will be in the future and what the maximum punishment is.
All right. And so, Mr. Jones, your first case ending in 7338C, which is a 2022 CR case. You're charged with one count of battery, family violence, second count of terroristic threats. Each of those charges carries a maximum sentence of 1 year in jail, as well as a $1,000 maximum fine. The Solicitor General's office has accused the case of those charges. Your case will be further noticed for trial and sent to the division judge to schedule that trial date. Just keep in contact. Obviously, if you get out on bond with your attorney, keep your address current so that you will be able to receive your notice of trial. And so your second case ending, this is a 22 CR case, ending in 7340C, wherein you're charged with one count of battery, family violence. You're charged with 2 counts of cruelty to children in the 3rd degree. And again, each of those charges carries a maximum sentence of 1 year in jail, as well as a maximum fine of $1,000 each. And again, the Solicitor General's office has accused these cases, and your case will be sent to the division judge for their notice for trial. All right. You've been formally arraigned on both.
Who is this calling?
Or no, he's got his hand up.
Your Honor, no.
Yes.
Yes, Your Honor. I was offered a plea for my first case, and I wanted to take my plea. They switched my public defender, and me and him wasn't clear yesterday. I want to take my plea for my first case, my plea offer for my first case, for time served for the 88 days.
Your Honor, the second, if he pleads to the first case as noted in the calendar, the second case, they're going to go forward as a felony. Your Honor, he has spoken with another public defender. I would encourage him to talk to the public defender again. Also, he has indicated that he has reached out to, he named 2 private practice attorneys. I have not reached those people, so I'm not clear whether they are yet hired or whether the family is about to hire them or has hired one of them. I would suggest he pursue it that way. what he's proposing to do today in pleading guilty to one case without doing a global matter is, I think, not a good way to go. And I would advise him against that.
All right, Mr. Jones, has your family hired you a private attorney?
We have, but he's handling my new case. I also have a new case. He's not handling this case.
Okay, then this case, you have a public defender who they're giving you sound advice. I suggest you talk to them a little more because there's some grave implications. But if your new attorney is not representing you on these cases, then you still have the public defender representing you. They're giving you some sound advice.
Okay, can I talk to him?
Normally what we do when there's one attorney on the worst case and we're on this case, we speak with the attorney who is on the worst of the two cases and ask them what they think of whether our case would affect theirs, because more consequence. We haven't had that conversation yet, so this is premature. He should not plead guilty to number 20 today.
Right, I'm going to hold on your guilty plea. Have your attorney to call Mr. McLean or talk to him about it so that you don't do something totally against your interest that you were not prepared for. It's for your own good at this moment. So I'm going to hold on the guilty plea.
Okay, so
and I meant to say 24, not 20.
Okay.
No, nothing about my case.
So if you have a private attorney, Mr. Jones, he needs to talk to the public defender.
Am I being reset, Your Honor, or?
Yes, you'll be reset.
That's the best thing for today is that resetting. Thank you.
All right.
I appreciate you.
South Annex, you all can go. South Annex,
Can I do position number 30?
Go ahead.
you all can go.
All right.
Your Honor, and if that's Mr. McKinnon on the South Annex, is that?
Who was that? Is that Mr. McKinnon?
I believe that's Mr. McKinnon on the screen that says only the two words South Annex.
I see sports. No.
Raise your hand, South Annex.
Oh, down there. I'm sorry. All right, you, Mr. McKinnon.
Right, Your Honor, at this time, this should be a not guilty and go to the trial court, which I believe it's a C if I recall correctly, and that would be going to Judge Dixon. I'll speak with the attorney in Judge Dixon's courtroom about this case. We'll do that as soon as possible, Your Honor, because the amount of time he has served is very rapidly approaching the 6-month mark, which, if he has good behavior in jail, would account for a 12-month recommendation the state has made. So we'll try not to waste time on that. And he has another matter, Your Honor, with a $20,000 bond that he cannot afford. So at this time, with me waiving formal reading the accusation, asking for a simple arraignment in which the court tells him what the maximum punishment is and tells him that he'll be in court soon. With that, Your Honor, bond is moot at this moment.
All right. We'll do that. Mr. McKinnon, your case is 23 CR 004835C. You're charged with 1 count of simple battery, family violence, 2nd count of simple battery against a person 65 years or older who was pregnant at the time of the offense. And for each of those charges, your attorney has waived the formal reading of the accusation. You have been accused and charged in both cases by the Solicitor General's office, and each of those charges carries a maximum fine of $1,000 each, and also a maximum time for incarceration at 1 year. Your cases will be reset for a jury trial with the division judge who they're assigned to, and you've been formally arraigned in both cases.
Thank you, Your Honor.
All right, thank you.
Position number 37, Rogers.
Okay,
37.
is Marquez Rogers, 22 CR 003870J. Charge of 1 count of simple battery, 2nd count of obstruction of a law enforcement officer. And what's the announcement?
Your Honor, this is a bond hearing for Mr. Rogers.
All right. Pre-trial, you have the history?
Yes, Your Honor. Defendant, he has 9 arrest cycles beginning in 2013. He does have a misdemeanor conviction for marijuana possession less than 1 ounce, took a NOLO plea on that March 2013.
All right.
He has another, misdemeanor conviction for a disorderly conduct out of Fulton County. Disposition date on that is December 2017. He has 1 violation of probation, and looks like his last arrest was out of East Point, and that was August of 2021, and that was for simple battery and willful obstruction. I'm sorry, hold up, let's see. On here twice. No, I'm sorry, out of East Point for theft by shoplifting, misdemeanor theft by shoplifting. And that was bound over February of 2020. It doesn't say where it was bound over to, but it was bound over, and no other dispositions listed for that case, Your Honor. Nothing to add.
All right, state.
Your Honor, Charles Ford on behalf of Marquez Rogers. Your Honor, we're asking for that Mr. Rogers' bond be reduced to a signature bond. He has been incarcerated for 59 days on this particular offense. He's a high school graduate. He's also an on-call worker for Coca-Cola. He has 4 children, Your Honor, that he does give financial support to. He's a lifelong resident of Georgia. He definitely has community support, because I do have a telephone number for his sister who lives here. He has a stable address, Your Honor. We feel, based on the fact that he has been incarcerated for 59 days, Your Honor, and then as you can hear, that he has a minimal criminal history, and he does have a job. He was working for Coca-Cola. Your Honor, he wants to get back to that so he can actually provide financial assistance for his family. Your Honor, we're asking for that signature bond because of the 59 days and his limited criminal history and his background.
What is the current bond?
It's like 1,000 on each case, Your Honor. 1,000. That's what I have.
Your Honor, I have, for count 1, I have 1,000 surety, and then for count 2, I have a $0 signature bond.
Okay. For some reason, I had 1,000, so 1,000 surety bond, Your Honor. I did have $1,000 for the obstruction as well. But if they have a signature bond, then Your Honor, we'll go with that. But we ask that to be reduced to a signature bond, Your Honor, at this point. The entire bond.
All right, state.
Your Honor, this incident happened August 19th of 2021. Defendant's accused of using both his hands to push and shove his sister and then slap her. And then when officers arrived, he failed to provide his name and date of birth. Considering that, count 2 is a signature bond, the state believes that count 1, 1,000 surety bond is more than reasonable.
All right, go ahead.
Yeah, he's been in for 59 days, Your Honor, on this case, and he does have employment, he does have family that he needs to support, and he does have support of family, Your Honor, in this matter. So we ask that the entire bond be a signature bond.
Does he still have his job after 59 days?
Your Honor, and he does have another job at the Madhouse, Sparty. He's hoping he can recover it, Your Honor. That's what he's trying to do at this point, to make sure.
Okay.
He was an on-call worker for Coca-Cola.
Does he has a separate address, obviously, from the sister? Or there's a stay away there?
Yes.
All right, I'm going to order on the first charge, a $3,000 SOB. Trying to think if we want to do monitoring or not through pretrial or jail. I assume he will be back for court.
We will, Your Honor.
All right, I'll do a $3,000 signature bond through the jail on the first charge, and the second charge was a zero amount SOB jail as well.
Okay.
And then we're gonna also make sure that there's no further contact to Destiny Tent and to stay away from the incident location. And that should, no drugs, alcohol, weapons, guns while on bond.
All right.
All right.
All right. Thank you, Your Honor.
Uh-huh.
Position number 7, Mr. Campbell.
Good morning, Your Honor. Thank you for being here.
Let's see, Jerry Lee Campbell, 23 CR 005222H. Charged at 1 count of criminal trespass, 2nd count of willful obstruction. This a time served plea
I believe they were asking for a bond hearing. Is that correct, counsel?
or no?
Angela, my counsel is coming forward.
Okay,
1 second, I think.
Position 7.
Thank you, Your Honor. And still not guilty. For position 7, we'll be entering a plea of not guilty, and I'll submit a waiver of arraignment. We would request to address bond.
what is the bond?
I believe it's 1,000 to the 1 count of obstruction. I have to locate the bond for the criminal trespass.
Okay,
It's a total of $2,000 surety bond, Your Honor, is my understanding.
It's 1,000 on each, Judge.
okay,
And we could have pretrial read the history.
okay.
Hey, come on. This is Mr. Campbell, correct?
Mhm.
Yes.
Mr. Campbell, he has 11 arrest cycles out of Georgia beginning in 2010. It looks like he has a pending case out of Dunwoody. Arrest date was March 2022 for terroristic threats and hoax devices. There's no disposition listed on the GCIC. His last arrest was out of Atlanta, November 2022 for Clayton County, out of Clayton County, for disorderly conduct, resulted in a misdemeanor plea. He took a NOLO plea December 2022. He has 2 FTAs. GCIC also indicates a hold out of Miami, Florida for trespassing. That warrant was signed March 25th, 2022. He has 1 cycle out of Texas from November 2018. That was for, let's see, criminal mischief, resisting arrest, search or transport. And it looks like that case was dismissed April of 2023. And he has 5 arrest cycles out of Florida. Last arrest was February of 2022 for trespassing, disorderly conduct in establishment, resisting officer without violence. There is no disposition listed for that case. And let's see. Nothing to add, Your Honor.
Yes, Your Honor.
Right.
In this case, law enforcement was dispatched to the target located at 3535 Peachtree Road. They made contact with the store manager who advised that they had asked the defendant to leave. He was refusing to leave. The officer made contact asking the defendant to leave. Yet again, he refused. At that time, he was placed under arrest for criminal trespass. He did resist arrest, and that is the basis for the obstruction. After hearing the history from pretrial services, it seems like the defendant is a multi-state offender. And most cycles that I heard were either disorderly conduct, criminal trespass, or resisting arrest. And that's essentially what we have before the court this morning. So with that being said, we feel that the $2,000 surety is more than appropriate. We would ask that it remains as said.
All right. Is it Mr. Dotis?
Yes, Your Honor. Yes, Mr. Campbell is 34 years old and he's currently being held on a $2,000 surety bond that he cannot afford, which has kept him in custody for the past 17 days. We are requesting a signature bond because he cannot afford any monetary amount of bond. As we heard from pretrial, the only closed case that I heard was a 2022 Clayton County arrest that ended in a no-low plea. I didn't hear any dispositions on any other cases. Mr. Campbell does maintain his innocence. Regarding, he did bring up, he was aware of the FTA. He says that was during COVID when he was just given a notice and that's why he missed court, but he is clear moving forward on what's required of him and that he needs to stay on top of his court dates, which he knows to do. I do have a good contact number for Mr. Campbell. He has been in the state of Georgia for the past 15 years as a resident. I do have a good address for him in Atlanta, Georgia. He will provide me with his father, Freddie Campbell's number upon his release. And he also provided me with his sister, Brandy's phone number. So he does have family support as he goes through this, but they're unable to monetarily support him. He currently works doing freelance work through the Quick app, which is part of LGC Hospitality, where he believes he can continue working. And when I spoke with Mr. Campbell about this case, he tells me that he left the Target store and was approached across the street at Publix by the officer. So it wasn't in Target, so he does dispute the facts. He tells me he left the location and then an officer came and escalated. Of course, he wants to be a part of his defense, and we want to go over all video evidence if there's body on camera to see to sort out the two stories. But at this point in time, we are requesting a signature bond so that Mr. Campbell can be a part of his defense and not remain incarcerated.
And Your Honor, if I could just respond to something that counsel said pertaining to the record. I have 3 convictions. 2 of those are disorderly conducts just from this year. So there's more than the NOLO as it pertains to convictions, because I'm showing 2 disorderly conduct cases here in Fulton County that were disposed of with guilty pleas this year.
And I was just going off of the pretrial report. My apologies if I left anything
I
off.
understand. And I have those case numbers if you would like. It was 22 CR 00456J, and then there's 22 CR 004-471J.
Thank you, Mr. Walker.
All right, on Mr. Campbell, I will go ahead and enter an order of on the first charge. I'm going to make that a $2,000 signature bond through the jail. And on the second charge, I'll make that a $1,000 signature bond through the jail for a total of $3,000 SOB jail. I'm going to order stay away from that target on Peachtree Road. No drugs, alcohol, weapons, or guns while on bond. Anything else?
Nothing from the state.
Okay,
Thank you so much, Your Honor.
Thank you, Your Honor, and I'll prepare that order.
all right. All right,
Position number 8 and 9, Your Honor. Mr. Collier.
what number again?
8 and 9.
8 and 9, okay.
Say again?
And these pleas are,
I believe so, Your Honor.
Your Honor, apologies. I thought my attention was needed. They are both pleas. We will note, for position 8, we would ask probation to be concurrent with a separate case that Mr. Collier did enter a plea with on August 15th. That was 23 CR 004704Y. Just so his probation runs concurrent since he hasn't had a chance to start either. And then position 9 is the time served negotiated plea.
all right. First case is 23 CR 003220Y, Derek Collier, charged at 1 count of simple battery, family violence, 2nd count obstructing or hindering a person making an emergency telephone call. State.
Yes, Your Honor. The state's recommendation is 12 months to serve, 90 days. Credit for time served, 45 days. Balance probated with the conditions of a FBIP course. No further contact with the victim, a Miss Janelle Ricks, and to stay away from the incident location, 3984 Adamsville Drive.
Is that your understanding, Mr. Dotis?
Yes, Your Honor, that's our understanding of the plea offer, and we do stipulate to the factual basis, venue, and ID.
All right, and then the second case.
I'll just ask.
Yes, in the second case, Your Honor, that's going to be a time serve offer, balance suspended with the conditions of no further violation of Georgia law.
All right. That your understanding, Mr. Dotis?
Yes, Your Honor.
And we have to put an amount of time. We put down time served 24 hours, credit for time served 24 hours.
Okay.
I just put 5 days in the plea paperwork.
Okay, 5 days.
Hey, yeah, sorry. Hate to have to cross that out, make it messy.
It could be 5 days. I don't think he's being held on that charge, but as long as it's time served.
Right.
All right, Mr. Collier, you're wishing to plead guilty in both cases, is that correct?
Yes, ma'am, Your Honor.
Okay, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and I'm going to ask you a series of questions to make sure your plea is free and voluntarily and you understand what you're doing, okay? First question is, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
You're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you to receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by the guilty plea today?
I don't know about that part. Yes, ma'am, but I guess so.
Okay. And do you offer this guilty plea to these actually 4 charges, free and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, so as to the simple battery, family violence, and the obstruction of the 911 call, how do you plead?
Guilty.
And then as to the failure to have license on person and giving a false name, how do you plead?
Guilty.
All right, so in the first case, You've got 12 months to serve, 90 days credit for time served at 45, balance probated, FVIP program, and no further contact and a stay away with the victim in that case. All right.
Yes, ma'am.
And then in the second case, it's a time served plea, no further violations of Georgia law. You understand all of that?
Yes, ma'am.
All right, I will accept your pleas and good luck to you.
Thank you, ma'am.
I apologize. What case was position number 8? What was case number of what he was wanting concurrent with the probation on?
Yeah, what was the other case to run concurrent? I didn't have that.
Yeah, so that was, Mr. Collier entered a plea on August 15th for case number 23 CR 004704Y. And we just want to make sure that they run concurrent upon his final release for all of these.
Okay, thank you.
Thank you.
Position number 43, Your Honor, Mrs. Smith.
Hey, Will, quick announcement for, what was the name? Okay, for, Phillips Devontae, 202, his attorney wants him to go again. Will, you got it?
Mr. Devontae?
Yeah, Devontae.
Yeah, he's still here.
Phillips, 202,
He's still here.
okay.
Which number is that?
33.
Position number 10, Denson.
And I did send a message in the chat to ASG Walker regarding position 10. I'm not sure if you responded.
I did not respond. I did receive it. To fill the court in, what the inquiry was about the condition of no further contact. The state has not had contact with his mother, so we're not comfortable saying no further violent contact. But ultimately, we will defer to the court in that matter.
Okay, we can address that, I guess.
Okay.
And
So go ahead.
for position to to provide an announcement, this would be, I guess, a non-negotiated plea. The only issue would be the no further violent contact instead of no further contact. We'd also request to enter a plea of nolo contendere.
Nolo in 10.
For position 10, yes, Your Honor.
Okay. So is that the one we're doing now?
Position 10, I believe so, Your Honor.
All right, 23 CR 005272G. Andrew Denson, charge of 1 count of battery, family violence, 2nd count of giving false name, address, or birth date to law enforcement. That's going to be a plea, is that correct?
Yes, Your Honor.
Okay.
And since counsel is requesting a nolo, we could have pretrial read the history, please. Opposition.
Pre-trial?
Yes.
Okay.
Mr. Denson, he has 9 arrest cycles beginning in 2006. He does have a felony conviction. Let's see. Well, felony case out of Fulton County for aggravated assault, possession of a firearm or knife during commission of or attempt to commit certain felonies, misdemeanor willful obstruction and robbery. Disposition date on that is July of 2007. He did receive first offender on that treatment and successfully completed that. July of 2017. He does have a misdemeanor conviction out of DeKalb County for forgery in the 4th degree. Disposition date is June 2015. His last arrest was out of Fulton County, December 2016 for a probation violation. The GCIC does indicate a hold out of Anniston, Alabama for a misdemeanor probation violation. The warrant is from 2015. He has 1 cycle out of Alabama for possession, forged instrument in the 2nd degree. Disposition is not listed on the GCIC. but that case was from 2015. Let's see. Oh, one moment, Your Honor.
Mm-hmm.
And I don't see the hold on his jailing screen, just the case that's on the calendar.
Mm-hmm.
Nothing to add, Your Honor.
Okay.
No, Your Honor, in this case, law enforcement was dispatched to 189 Rhodesia Drive. They spoke to the victim, who is the defendant's mother. Her name is, one second, Janice Denson. She advised the law enforcement officer that her son was acting erratic, at which time he became violent and he did slap and punch her in the face. The officer did observe visible swelling on Miss Denson's face. At that time, warrants were taken out for battery family violence. He also gave a false date of birth, and that is the basis for that charge. The state's recommendation is 12 months to serve, 30 days, credit for time served, 15 days, balance probated with the conditions of an FFIP course, no further contact with the victim, Janice Denson, and to stay away from the incident location, which is 189 Rhodesia Drive. And again, the state has not been able to make contact with the victim, and that is the purpose, or that is the reason why we are asking for no further contact. We believe that the victim should and will be able to come forward if it was her desire to have contact with her son. And as of right now, we have not made that contact with the victim.
All right. Mr. Dotis?
Thank you, Your Honor. As we heard from pretrial, I believe the only violent case I heard was from back in 2015, where he did complete his first offender. Since that time, there have been no further violent history, so we would request that Mr. Denson be allowed to enter a plea of nolo, as he's not used one in over 5 years. Regarding no further contact, we would request no further violent contact. That was given and was a part of the bond order signed on August 30th by Judge Williams. We'd ask that to ensure that to help repair the family and ensure that Mr. Denson is able to be seek any assistance that his mother may be able to provide him with if she chooses to. My understanding is, I'm not sure, is that she should have been present if no further violent contact was granted at the bond hearing. So we would just ask that to carry over to the plea. And we are fine with all other conditions. Mr. Denson is clear on what's required of him, but nothing further.
Okay. So you're asking that this be a nolo plea?
Yes, Your Honor.
All right. Believe it sounds like I can accept the nolo plea. I don't hear that he has used it in the last 5 years. So Mr. Denson, are you ready to take your plea?
Yes, ma'am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you put your hand down. Tell me this, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes. Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So as to the charge of battery family violence, how do you plead?
No.
And as to the charge of giving false name or address, how do you plead?
No.
Okay. All right. I'll accept your no low plea to the two charges. And again, you've heard the conditions that you have to do an FVIP program, stay away from the incident location and no further contact with the victim, your mother, Janice Denson, while you're on probation.
Okay.
Okay?
Yes,
All
ma'am.
right, good luck to you.
And Your Honor,
That's a no further violent contact or no further contact? I'm sorry, Mr. Dotis.
Oh, yeah, which was it? I thought it was no further contact, but you tell me, Mr. Dotis.
defense would request no further violent contact to allow the family to work on repairing itself. Again, that was in place on the bond order signed by Judge Williams on August 30th. We'd like that to remain the same for the plea.
And I think, Mr. Walker, did you state you had not spoken to the victim, so you were not sure about that? You're on mute.
That is correct, Your Honor. We were unable to make contact with the victim since the inception of this case, and that was the reason we were asking for no further contact, because it's unclear of the victim's wishes at this point.
I'm inclined to do no further contact, and because I don't want to again put the victim in harm or he go back to the home and we start this cycle all over again. Don't want to do that. So I'm assuming he has a different address and somewhere else to go live.
Your Honor, he is residentially challenged at this point. He was providing on the support of his mother and father to assist him. He says he couldn't remember off the top of his head, but he will provide the court with his father's updated address upon release. But it's not, my understanding is that he can't remain there indefinitely. It's more of a mailing address.
Well, we were ordering a stay away from the incident location, which would obviously be his mother's address. So he can't go back to live there. I understand he may be challenged, but he's going to have to make sure he finds somewhere else to go live. I'm not going to send him back there without having talked to the mother or the father. I don't know if they sound like they live at different addresses, the mother and the father.
That's my understanding from talking with Mr. Denson.
Well, we want him to stay away from the mother's address and to have no further contact with her right now, unless she reaches out to one of us to state that she's willing to have contact. I don't want to send him into that right now. So let's do this. Stay away and no further contact with his mom.
Understood, Your Honor, and I did go over this possibility when I met with Mr. Denson yesterday, so he's clear on what's required of him.
Okay.
Position number 23, Johnson.
Mr. Walker, I apologize. The address for the mother was the Rhodesia Avenue, correct?
Yeah, 189, I believe.
Okay, thank you.
Position 23, Johnson.
Okay. This is 23 CR 005266E. Martirius Johnson, charged at 1 count of SB. Is this still a plea?
Yes, Your Honor, it is.
All right, state.
Yes, Your Honor. The state's recommendation is 12 months to serve, 60 days. Credit for time served, 15 days. Balance probated with the conditions of a SDET course. No further contact with the victim. I'll spell the first name. It's spelled OLAYEMI. Last name is spelled AFORIN. And there's going to be a stay away from the incident location, which is a racetrack gas station. If I could just have 1 second, I can give the court that address. It is.
What position is this?
23.
23.
I believe. That address is. Oh, 1180 Virginia Avenue in Hateville.
Okay.
Your Honor, I've discussed the case with my client. We discussed guilty versus not guilty. We discussed negotiated versus non-negotiated. He has decided to accept the state's offer as it is. So that's a negotiated plea.
All right. And Mr. Johnson, you wish to plead guilty, is that correct?
Yes, Your Honor.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down and speak up just a little bit for me so I can hear you. The questions I'm going to ask you, a series of questions to make sure your plea is free and voluntarily and that you understand what you're doing. And the first one is, are you under the influence of any unprescribed medication, drugs, or alcohol?
No.
I'm sorry?
No.
Okay. Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
That you're giving up or waiving the right to remain silent and not testify against yourself?
No.
I'm sorry, that you are giving up the right to remain silent and not testify against yourself? Do you understand that?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
Okay, and are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you would receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea today?
Yes.
And so again, you've heard what the conditions are, the SDET, no further contact, and to stay away from the racetrack and the victim in this case. So you understand those conditions?
Yes.
All right. And so with that, I will accept your guilty plea, and that will conclude this case. Anything else from counsel?
Yes, Your Honor, he is residentially challenged. He does have a mail address with which I will put the contact sheet for probation. But other than the mail address, he doesn't have an emergency contact, but he is residentially challenged and is struggling financially. So I'd ask the court to give him as big a break financially as it can possibly stand.
All right. I will waive 6 months of the probation.
Thank you, Your Honor.
Your Honor, position number 33, Ms. Phillips.
Okay. What are we doing here?
Your Honor, this be a non-negotiated plea.
Okay. So, Mr. Phillips, do you wish to take a plea today?
Yes, ma'am.
All right, and you understand what you're doing with the plea, is that correct?
Yes, Your Honor.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
And so, Mr. Ford, you've had a chance and you've talked to Mr. Phillips?
Yes, Your Honor, the state has made an offer and at this time, and we want to enter a non-negotiated plea. And also, Your Honor, we do have the alleged victim on the line as well, Ms. Valencia Watson. And so we'd ask to have a statement from her as well.
All right. So Mr. Phillips, again, you're 23 CR 005238Y, charge it 1 count of simple assault, family violence. Ms. Nimini, do you want me to go forward with the victim first?
Yes, Your Honor.
All right, where's the victim? Miss Valencia Watson?
Yes, I'm here.
Where are you? All right, in order to talk to me, I have to see you.
I have my camera on, but for some reason it's not showing me. It's just showing the background. I don't know how to change that.
Well, you'll have to figure it out. So I can't speak to you. Meaning, did you sign on and said that you wanted video and audio?
Yes, I have my
Because I have to see you and swear you in as well.
Okay. I'm gonna have to change some settings, so I apologize.
All right. And you wish to testify today before the court? Regarding-
I received a call, so I just was welcome to join.
Your Honor, she received a call from me. My client had asked for me to have her on Zoom because this is a non-negotiated plea, and we are looking to have no further violent contact. Also, Your Honor, we're asking to have his jail time reduced from the state's offer. And also he's willing to do additional anger management. The state's offer was 120 days, credit for 15 days, Your Honor. We're asking for 60 days, credit for 15. Also, we're asking that the 40 hours of community service that was offered by the state be moved to 80 hours. Rather than do the jail time, he'd like to do community service, Your Honor. And everything on the state's offer would remain the same. Except for we'd have to have a no further violent contact with Valencia Watson and her children. And that's why we asked Ms. Watson to be here to speak to the fact that she's not in fear of Mr. Phillips, and she would be okay with the fact that he would be out of jail. If it's 60 days, he'd be out another 15 days in jail.
All right, Miss Watson, you've heard the attorney for Mr. Phillips. Raise your right hand for me. Can you hear me, Miss Watson?
I can hear you now.
Okay, can you raise your right hand for me? So I can swear you in. Do you affirm the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, and so put your hand down for me. And so is it my understanding that you wish to have contact with Mr. Phillips?
Yeah, no violent contact.
Okay, you all have children together?
Yes.
How many?
4.
How many?
4.
4? How old are
Yes.
they?
8, 6, 2.5, and 10 months.
Okay, do you all reside together?
No.
And so you're not in fear of him and would like no further violent contact?
That's correct.
All right, any cross-examination questions from the state?
Yes, Ms. Watson, when we initially met, did you tell the court that you didn't want any further contact with the defendant and your children?
Yes.
Has that changed?
Yes.
Can you tell us why it's changed?
Because I would just prefer to have no further violent contact.
Okay, just want to get a little more clarification. You said that y'all have had incidents in reference to family violence for some time now, correct?
That's correct.
This isn't the first time.
That's correct.
You're not in fear of the defendant?
No.
Okay, that's it, Your Honor.
Any cross-examination, Mr. Ford?
Just one question, Ms. Watson, is this, even though you do not, Mr. Phillips does not stay in the same, at the same address, you have no problem with him having contact with the children either, do you?
That's correct.
Okay. All right, no further questions, Your Honor.
And you know, Ms. Watson, we just want to make sure that you and your children will be safe. And that is the court's charge to make sure that you will be, and that you feel safe if Mr. Phillips gets out, and that there won't be any further incident. And we're making sure you're in agreement with that. And you understand what that means.
Yes.
Your Honor, sorry to chime in so late, but this is a moot point. She has 3 previous convictions, or he has 3 previous convictions with the victim. He's currently under a 5-year sentence, so he can't even have contact. With that being said, I would ask Ms. Nimini to give the factual basis of this case and let her make her argument to the court. But I do want to be clear that they have 3 previous felony convictions together where she's listed as the victim. He's currently under a 5-year sentence with a no contact. So that's really a moot point.
All right, Ms. Nimini?
Yes, Your Honor. So I did put the facts on the case earlier, but just to refresh your memory, they got into an argument. Property manager sent an email out stating that someone was impersonating a police officer, a security officer, and he was arguing with a Black female with an infant in her hand. When officer spoke with Ms. Watson, she did state that the incident occurred at the gas station, and then they got home and he had threatened her and pulled out a knife as she was trying to leave the area. And then once they got to the location, that's where he took the pocket knife out and stabbed her car tires. And he became irate, and he said that he was going to stab her with the pocket knife. Considering that the state is going to oppose for what the defense counsel said, the state is going to stay at the 12 months served on 120 days. The credit for the time that he has served, we're going to stay that he has no further contact with the victim. In addition to her minor children, we're going to want that 12-week of anger management. If the defense wants to give him 80 hours of community service, the state doesn't oppose. I just want the court to know that because there's 2 previous family violence cases with this victim and a felony terroristic threats in reference, and also robbery, defendant is a multi-offender, violent offender, and the state is going to stand for their recommendation.
Okay.
And, yeah, all these were her. The cases that I just stated are all this victim. And when we spoke to the victim less than 2 weeks ago, she didn't want contact with him and her minor children. And she said she was in fear of the defendant. Now, I don't know what has changed, but we're trying to advocate for the victim in this case. Again, we don't want things to turn lethal.
All right. Ms. Watson has turned off your camera again.
Your Honor, I'd like to address the court whenever you feel it's appropriate.
All right, go ahead, Mr. Ford.
Thank you, Your Honor. Your Honor, you know, the state wants to make light of the fact that Ms. Watson is here. She has stated that she would not have any problem with no further violent contact. The defendant and alleged victim do not live together, so she wants to have some type of connection, because they do have 4 children together, Your Honor, and the youngest one is only 10 months old. Mr. Phillips was working and he feels he can get that job back as security at No Limits Investigation and Security. That will definitely add financial support to the children, Your Honor. We're asking for 60 days, Your Honor. He's already done 15. We're asking for 60 days. And the only reason we asked for 80 hours of community service was not for him to do 120 days, but for him to do 60 days and do 80 hours of community service. That's just to show that he is committed to helping out in the community, Your Honor, rather than stay incarcerated for that period of time. So we're asking for 60 days, 80 hours of community service, and he's willing to do the 12 hours of anger management as well, Your Honor. So at this point, with this non-negotiated plea, Your Honor, we are asking for 60 days, credit for time served, 15 days, that Mr. Phillips do 80 hours of community service and 12 hours of anger management, and there be no further violent contact with Ms. Valencia Watson and her children.
Your Honor, I'm sorry to interrupt. Is counsel suggesting that the defendant violates his open felony probation? Because again, he's on felony probation with a no contact order, so I don't see how you're asking for him to have contact. You would be in violation of that probation order.
Your Honor, I'm just asking for this case, Your Honor, that the statement be no further violent contact. If Mr. Watson has made.
He is on 5-year probation. That would supersede this case as if this is only 12 months. So again, I'm not sure how he would be able to have contact over the next 12 months when he's under a 5-year sentence with a no contact order. That doesn't make any sense at all. And it's misleading to the court and your client.
It makes perfect sense. I don't have that document in front of me that he's on 5-year probation, Your Honor, with no contact.
That doesn't mean it doesn't exist just because you don't have it. I do have it.
But you have it, that's okay. You make your statement, I'll make mine. Judge can make her decision. Your Honor,
Again, I just want to clear up any, wrong information that's being relayed to the defendant or the court. I just want to make sure the defendant understands that due to his felony probation, he cannot have contact.
Right, if he's still, Mr. Ford on his felony probation, I don't want to contradict that or to have him to be violated to go back. Pretrial just came on. Do you have
Yes.
that pretrial?
It's 10 years probation
Oh,
because the first offender was revoked. So they gave him 10 years probation.
and no further contact, correct?
It doesn't say that on the GCIC. I don't have access to Cobb County, but it's 10 years probation after they revoked this first offender.
So I believe that counsel, I believe pretrial is speaking to another case. I'm just speaking of his cases here in Fulton County.
That's correct. You're right. That's the Cobb County. I'm not sure if it's the same victim, but it is another battery against a female who is pregnant. Not sure who it is, false imprisonment, but he still has 10 years probation.
Your Honor, it's just not clear.
It's clear, 21 SC 178123. The final disposition is in Odyssey, which we all have access to. And again, that's a 5-year sentence with no contact with a Miss Valencia Watson.
What was the police number again, Your Honor, Mr. Walker?
What was the case number? It's 21 SC. Hold on, because I have so many windows open. 21 SC 178123. And that's a battery, felony violence, and a cruelty to children in the 3rd degree. He entered a plea June 30th of 2021. And looks like is a 3 years to serve 2 years probation with the condition of no contact with Valencia Watson. So he clearly is still under that sentence. He will be under this sentence for at least the next 12 months. So therefore, due to this felony probation, and this is just in one of his cases, there's another no contact order in the other felony case that he has with the victim. So again, he has 3 previous convictions with Miss Valencia Watson listed as the victim.
Yeah, we've just pulled it up. We do see the no further contact for the 5 year.
Right, I just don't want to have any conflicts with that, nor have him to violate in any manner.
Verify, Your Honor, that's all. I don't think I'd be doing my due diligence if I just didn't at least see it for myself.
Right. Well, I am not inclined to allow him to have contact with her at all. I'm not really inclined to say with the children at this point because I'm very, very concerned about his history and his history with the same victim. I don't want to put anyone in danger just because she came on today. If 2 weeks ago she didn't, I don't see what has changed except maybe she's just, still afraid and trying to help him to get out. And I don't want to put my victim in such a situation as that, or the victim rather, in such a situation as that. So I'm going, if we're going with this plea, then again, it's going to be no further contact with Miss Watson and her children.
That's fine, Your Honor.
We'll stay with that. With the credit for time served at 60 days for 15, I wrote down 15 instead. 12 hours of anger management. So you all are going to have to read me the plea again because I'm very confused on what we're doing.
Okay. Your Honor, the state has offered 12 months probation, 120 days to serve with credit for only 15 days, Your Honor. And then
Right.
and so we're asking for it to be not 120, but 60 days, Your Honor, with credit for 15 days. And also, we're asking for 12 weeks of anger management instead of 40 hours of community service, Your Honor, we'd ask for 80 hours of community service with the reduction of the 120 to 60 days.
Yeah, I don't feel inclined to give him credit for less. I'm just very, very disturbed a little bit with all of the history and with the same victim. I'm not for sure that it's ready to give that reduced time. Not for sure that I'm comfortable with that. Don't want to, again, put the victim in any additional harm or any potential harm from her children's father. I understand they have 4 kids, but the history is just too great and too much history for me to do it. At some point, they may start over, but not just quite yet. These other cases are very close in time. You know, they're not 10 years up the road. They're in the last several years. So I want to make sure that she and her children will be safe. So he would have to serve how many more days?
Well, Your Honor, with the 120, he'd have to serve 45 more days, Your Honor.
Yeah, and the basis for the 120, Your Honor, is based on these 3 previous felony cases. The state feels that is more than reasonable.
Right. I would be inclined to go with the state on their side to have him to serve the other 45 days.
All right, so the question would be to Mr. Phillips. Mr. Phillips, you've heard the judge. The judge is taking the state's recommendation of 120 days and credit for 15, which would mean that you'd have to serve 45 more days on this case. You'd have to do 12 weeks of anger management and 40 hours of community service. Are you willing to plead to that? And I've also asked the state for a reduction in to disorderly conduct, and they have said no to that. They've rejected that as well.
Will you ask your question?
Yes, go ahead, Mr. Phillips.
Yeah, I'm for first, second, or third. If this the case, obviously, defendant is it's kind of a roller coaster cycle thing with me and her. I have no problem with just hear me. I have no problem with Miss Valencia Watson at all, or my children. I never would hurt my children. Never have hurt my children. If it's been a cycle like this, obviously it's not just my end that y'all just focusing on me. It's 2 people inside this whole thing. It can't just be focused on me. Every time I get time, I have to reset my life too. I got to start over. I'm tired of starting over too. I understand y'all tired of us going back and forth, but you can't just always point me out to be the bad guy. And every time I plead guilty just because I feel like the jail tries to trap me in some stuff, and I'm eager to get out because I know I got stuff I live for too. I have 5 kids in all, just to make this clear. I have 5 in all that I do provide for. I do a great job at being a father. I mean, not much to really be said besides I'm not trying to lose what I've already established myself at. You know what I'm saying? And I feel like this is just another reason to get me back in a position where I have to figure things all the way back out again.
Your Honor, we're focused on him because in this case and in multiple cases, he's the abuser. He does have 5 children. However, there are cases with the other baby mother. You asked him if he was okay with taking the 45 extra days. So if we can focus on that, Your Honor.
That's what we're focusing on.
Right, I understand, but hold on, Mr. Phillips. We want to make sure that you are are truly focused at not coming back down here anymore. That's the key. And every time you've given those opportunities, you come back again, and you're given another opportunity and you come back again. So we want the cycle to stop as well.
Right.
And even if you don't hurt your children, you hurt their mother in front of them or when they're around. So people will tell me, well, I didn't do anything to the children, but doing something to the mother is also victimizing the children as well, because they are witness to that. They know about it. They know these children may be young, but I guarantee you they feel the pain that their mom will feel. So we want to make sure that if you are truly done, and if you're finally done and you're going to turn your life around, that's what we want you to do. But I'm going to ask you to serve those other 45 days just to make sure we don't see you again, and that you are on probation with these other cases. So you've got a long time to continue to work on yourself, and take these anger management courses and find other ways to deal with the problems that you may be having with your child's mother or any other woman for that matter, and come to the conclusion that I'm just going to walk away and we're not going to have these incidents anymore. So I want to make sure that you understand that, because it's just too much for me to just look over and not consider, but also making sure that the victim, your children's mothers are safe and feel safe, that we did not fail them by allowing you shorter sentence to just kind of do a revolving door, get out, and then we, have other incidents. So that's what my ruling is going to be.
May I ask a question?
Is what they've offered. Yes.
How come it's like, I mean, I understand it's a woman's state. It seems like anytime I'm accused of something, I've got to be the bad guy of every situation. What if this situation was just so made up to the point where none of these things actually happen, and she just accused me for something? Then what? I'm just curious on how this actually works.
But this is not a woman's state per se. It's a state of justice based on the facts. When the police come out and the police are called and they investigate and they take testimony, they talk to the parties and they assess that. And so I don't know that you're always made out to be the bad guy, but certainly with the officers who would testify as to what they found when they came out to these incidents and what the evidence reveals, that you have to take responsibility for that, as a man and as a father, and set a better example for your children and for the child's mother. You made these children, so now they're here. Life can get tough, but you can't take it out in certain avenues. So that's what you're going to learn in some of these anger management courses, is how to deal with life and with situations and relationships in a much positive manner, so that hopefully for the next decade, we don't see you anymore. So you've got to get past your history, and you can't just blow that out the window and act like it didn't happen. You got to deal with it and then go forward. And if you go forward, we won't see you again. But you're on probation for these charges, and sounds like it's, 10 years, 5 years, whatever. It's quite a while that you've got to deal with it. So I can't change the fact.
Phillips, the only
I gotta go to Cobb County right now, so it's like still this gonna be prolonging what I have on the outside going on, and what I'm losing. You know what I'm saying? So it's all, everything right now is a gamble. And what I'm saying is, at least now.
Ronnie, it seems that the defendant is not ready to take a plea.
Doesn't sound like it.
I'm ready to take a plea. I just want to get to Cobb County and handle that, because I know that's gonna be more added on to what's going on.
Mr. Phillips, are you ready to take the extra 45 days at the state?
I'll ask the question. Mr. Phillips, you've heard the judge's recommendation that you'll have to stick to the state's recommendation of 120 days and credit for 15. Are you willing to take that plea at this time?
Yeah, I'm willing to take it.
Okay. All right.
Yeah.
Okay.
All right. I went over the paperwork with Mr. Phillips, I think as early as on Sunday, and thinking that we might get disorderly conduct, but that did not happen. So he's willing to take the plea. I've explained to him the
the issues of taking a plea versus not taking a plea. As you see, I was going to do a bond hearing earlier, and so he changed to a plea, but we're set to take the plea right now, Your Honor.
All right. All right, raise your right hand for me, Mr. Phillips. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes,
Okay, put your hand down for me. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
no ma'am.
Are you satisfied with the services and representation of your attorney?
Yes,
All right, do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
yes,
And that you're giving up or waiving the right to remain silent and not testify against yourself?
yes,
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
yes,
And are you prepared and agree to waive these rights today?
yes,
Has anyone told you you receive a lesser sentence for pleading guilty?
no ma'am, and I love to talk to my attorney after this.
Okay. Has anyone promised you anything to plead guilty?
No ma'am.
Do you understand that if you're on probation, your probation could be affected by your guilty plea today?
Yeah,
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
yes ma'am.
And as to the charge of simple battery family violence, how do you plead?
You said simple battery?
It's simple assault, Your Honor.
I'm sorry, simple assault. I apologize. It's to simple assault, family violence. How do you plead?
Guilty.
Okay. All right. I will accept your guilty plea of the 45 more days to serve with the conditions. And again, it's no further contact with Valencia Watson and your minor children while you're on probation with this case. And you have the 40 hours of community service and 12 weeks of anger management as part of the conditions of the staying away from her address, as well as no further contact with her. You understand? All right, thank you.
Position number 43, Mr. Smith.
Hold on, Will. I have a quick announcement for Oconee County. You all can go next. That's gonna be position number 32, Mr. Peak.
Okay. Is this Mr. Pete at Fort North or Fort South?
Oconee County, it's Oconee.
Raise your right hand.
Raise your hand, Mr.
Oh, okay, that's Oconee. Okay.
Yes.
Can we do a breakout with positions 1 and 2, with Mr. Dotis? This is Fort South.
Okay,
All right, Ms. Champion.
I need to have to be put in a breakout room with your economy.
Okay, for Oconee, they need a breakout. Mr. Ford wants to do a breakout with Oconee County.
So we need a breakout for Mr. Ford in Oconee County and Mr. Dotis in Fort North, correct?
Fort South.
Fort South, I'm sorry.
So who does that leave us with, Mr. Ford?
That leaves us with position number 43, Mr. Smith.
Hold on, Will, hold on. Who, is this your case?
I got it, yeah. This is my last one. I think it's very much.
Okay. And then while we're,
So,
for Mr. Fountain, that's gonna be position number 14. Notice.
let them know the economy is going to break up. Okay, 1 second, sir. I have one more client and then I'm gonna join the breakout room, okay? Just bear with me. I'll be quick, one. Hey, there it is.
Yeah, you need to use the restroom? I don't have my keys.
Oh, really?
Next.
On that, so.
You're next.
Are we, Your Honor, my apologies if I missed an announcement. Are we ready for position 14?
I don't know. I was waiting on the deputies.
Yes, we're ready for position 14.
Okay.
And this-
Anthony Fountain,
Yeah. And Your Honor, this is going to be a not guilty plea and a waiver of arraignment, and we request to address bond.
all right. This is 23 CR 005264Y. Anthony Fountain charged with 1 count of driving hit and run, 2nd count duty of a driver to stop at or return to the scene of an accident. And I have the not guilty waiver of arraignment, and we're addressing bond. State.
Yes, Your Honor, in this case, law enforcement was dispatched to 8100 Roberts Drive. They spoke with the victim, Ms. Chantrell McCree. She advised that the defendant made a illegal U-turn in front of her, striking her vehicle. She was able to follow the defendant and take pictures of him and his license plate number as he fled the scene. She provided this information to law enforcement officers, and they were able to positively identify the defendant as the driver in the car. Warrants were taken out. He currently has $1,000 surety bond. Just to give you a little bit about his history, or more specifically, his driving history, I'm showing that he has FTAs in municipal court for driving infractions in the year 2020, 2021, 2023. Again, that's 3 FTAs in the last 3 years in relation to driving offenses. Additionally, he pled NOLO to speeding in 2021. He also pled NOLO to following too closely in January of this year. And he also pled NOLO to erratic lane change in January of this year as well. So we have a following too closely, erratic lane change, a speeding, all convictions, along with 3 FTAs in the last 3 years. Based upon his FTA history and his driver's history, it's the state's position that $1,000 surety bond is more than reasonable in this case.
All right. Mr. Dotis.
Yes, Your Honor. Mr. Fountain is 69 years old, currently being held on $1,000 surety bond, which he's been unable to pay, which has kept him in custody for the past 15 days. I do have good contact information with Mr. Fountain, including a phone number, as well as a friend's number that can get in contact with him, and his brother, Kerry Fountain. He has been a resident of the state of Georgia for 35 years, and I currently have a good address for him in Alpharetta.
Going in and out, in and out.
I'm not sure what that was. Mr. Fountain isn't currently working. He does receive SSI. Regarding the facts, Mr. Fountain states that no contact was made with the other car. The other driver was speeding. His vehicle never touched the other driver. He said that she was speeding and that she swerved and hit the median. Later, when he noticed she was behind him, he did voluntarily pull over to speak. He maintains that his vehicle had made no contact and didn't understand why she was still following him. There's no mention. The only damage on the victim's vehicle that's mentioned in the discovery I have is of the driver's side headlight. Officers don't make any mention of any damage or any pictures of damage where my client's vehicle allegedly touched the front passenger bumper of the victim's vehicle. My client left because it was his understanding that no contact had been made, and so he didn't feel he needed to stay. We would just request a signature bond. Mr. Fountain is clear this won't resolve the case, but he does maintain his innocence and wants to have his day in court.
All right. With his age, at 69, I hope he, as you stated, will have somewhere to go. I will turn that into a $2,000 signature bond through the jail. I will grant that. And again, no driving unless he has a valid license. And no drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor. I'll prepare that order.
All right, thank you.
Your Honor, position number 43.
43. Well, your next pay, look, are you ready for that? Yeah, but they're doing 43. Who's that? Is that yours?
No, that's, Charles.
Okay, for position number 43, that's for Mr. Ford's case. He's actually in a breakout. Oh, he's actually back. They're doing position 43. You're on mute.
I still have not been in the breakout room with O'Connie. So I can do 43 if you'd like me to do it right now.
I put you in the breakout room, Mr. Ford. Did you not accept it?
I accepted it. I was in it. I didn't know, but then I went out. So I haven't been in yet with O'Connie. But if the judge would like me to do 43, I can do that. Joshua Smith.
Yes, sir, Mr. Smith.
Okay. Your Honor, this is a plea. And it's connected with 43 and 42, which is the violation. And I had sent a email to Mr. Walker earlier today that there was another misdemeanor that we were hoping that we could resolve today as well. That was case 21 CR 000050J. Can you hear me?
Can you give me the case number one more time, Mr. Ford?
Hello?
Mr. Ford, can you give me that case number one more time?
That case is on the calendar for Thursday.
So maybe we should move this one for a global offer. It's 21 CR 000050J.
Have positions 1 and 2, Mr. Abernathy.
Hello?
Okay. Your Honor, which case are we handling? Are we handling 43 Joshua Smith, or am I going to be put in a breakout room?
Your Honor,
Your Honor, you're on mute.
I'm sorry, I don't know. Which case are we handling, Deputy?
Sorry.
I thought we were on 43.
I'm sorry, can we put O'Connie on the breakout because they're still waiting with Mr. Ford?
Okay, so Oconee County with Mr.
Oconee
Ford.
County is already in the breakout. They was waiting on Mr. Ford to accept.
Okay.
Okay.
Your Honor, can we do position number,
Well, let me go next. This went. Position 18 and 19, Mr. Harris. No, Mr. McLean.
yeah, just,
Rose, I can see them.
All right, Mr. Harris, is that what we're on? He has two cases.
It is 1819, a main case and an FTA associated with it. Your Honor,
Right.
we're asking to be arraigned. We do not need a formal reading of the accusations. And we are not asking for a bond change at this time.
Okay. All right, Mr. Harris. Where's Mr. Harris?
Courtroom 2.
Right here, sitting next to me.
Oh, next to you. Gotcha. All right, Mr. Harris, understand that you're entering a not guilty plea and you're waiving formal reading of the charges against you. Just want to make sure that you understand that you're being formally arraigned on the first case, 21 CR 004731J, charged with 1 count, possession of marijuana less than an ounce, and 2nd count of carrying a concealed weapon. And with that case, again, you're being formally accused by the Solicitor General's office, and each of these charges carries a maximum sentence of 1 year in jail, as well as a maximum fine of up to $1,000 for each charge. You will be further noticed for trial. Your case will be sent to the division judge to schedule that. And then, of course, you have the FTA as well. And again, it'll be further noticed for trial. Anything else?
Nothing, Your Honor. Thank you.
Thank you.
Yeah, can we do position number 22, please? Mr.
Okay.
Howard Demetrius.
Demetrius Howard, 20 CR 001822F, charge of 1 count of battery family violence. Is this still a plea?
Let's see, Demetrius Howard, Your Honor, is a not guilty.
All right, and an arraignment.
Yes, Your Honor.
All right, 20 CR 001822F. Mr. Howard, you're charged with, and where is he? 4 North? Okay. And you're charged with 1 count of battery family violence. I've accepted your not guilty plea. I just want you to understand that you're being formally charged by the Solicitor General's office. And with this charge that you have, again, the maximum sentence is 1 year in jail with the maximum fine of up to $1,000. For this charge, the case will be reset for a jury trial by the division judge, who will be handling that case and scheduling it. And you are being formally arraigned at this time. All right.
Position 1 and 2, Mr. Abernathy on 4 South.
Thank you, Your Honor.
All right, 22 CR 006950A. Richard Abernathy, charged at 1 count of criminal trespass. And then I have a second one, which is the FTA. Is this going to be the plea?
Yes, Your Honor, this is going to be a negotiated plea.
Okay. Date. You're on
I'm
mute.
sorry, I was on mute. In this case, it's gonna be a time served offer, balance suspended with a stay away from the incident location. I believe that is 1180 Virginia Avenue.
Okay. That's your understanding, Mr. Dotis?
That's our understanding, and we do stipulate to the factual basis, venue, and ID.
All right. Mr. Abernathy, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Ma'am.
Okay, I want to make sure you understand what you're doing and that this plea is free and voluntarily. Put your hand down. And let me ask you this, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am, I am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am, I am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea?
Yes, ma'am, I do.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am, I do.
All right, so that's a time served, balance suspended, and just stay away from that incident location, okay?
Thank you, ma'am. God bless you.
All right, you're welcome.
Position number 34 and 35, Mr. Rhodes.
Okay,
That's Attorney Ford, I think.
It is.
Yeah. Yep.
oh, is that Mr. Ford?
And 42.
That's on Mr. Ford.
Mr. Ford is actually on a breakout, so.
Right.
Will, you can go next.
I have, Mr. Moses, the Anthony for probation 1 and 2.
That'll be mine, Your Honor. We can go forward with that if probation is on.
Probation is on.
All right, this is 22 CR 0062222J. DeAnthony Moses, charged with 1 count of battery, family violence, and then the probation violation case ending in 1122. Probation.
Yes, Mr. Mosey owes probation fees in the total of $49. That's including the victim crimes fund. He obtained a new charge of simply battery in July 25th, 2023 in Fulton County. He failed to report to probation on 3 accounts, 2 in February and 1 in March. He failed to complete, see if he was to do family violence intervention program. He has 3 months and 4 days left on probation. Probation is recommended to revoke the main balance.
And how much is that?
3 months and 4 days left.
All right.
And Your Honor, I'm sorry. May I
Go ahead.
Okay.
Yes,
Thank
go
you.
ahead.
Yes, Mr. Moses did accept a plea in September of last year. He was not clear on what was required of him with that plea and wasn't clear that he had probation. At this point in time, in total, Mr. Moses has done 157 days of jail time on this case. We're asking that, Your Honor, this court just time serve this and close it out. He's almost at the statutory maximum of time that he could serve. So we would just ask that this just be closed out. Mr. Moses understands that it was his responsibility, but he has substantial jail time on this case and doesn't have time to ask this court to reinstate him. Mr. Moses does have 6 children, ages 9 to 1 year old, that he wants to get out and provide for. He currently has a job at SGIT Security, as well as 779 Cascade Thrift Smart. Both of those jobs are waiting for him, and he wants the opportunity to provide for his family. Regarding the new offense, it did occur on a MARTA bus. It was a family violence offense. He was riding the bus when the alleged victim from the previous case got on the bus. Her sister was also on the bus, and an altercation escalated. Mr. Moses tried to get off at the next stop, but the altercation escalated, leading to the new charge. But other than that, Mr. Moses has never intentionally sought contact with the victim, and understands in the future that if he sees her on a bus or in public, then he needs to not wait, immediately get off and steer clear. But again, given the significant amount of jail time, we would just ask that he be given credit for the 157 days he served, and be given time served to close this out.
All right, any other rebuttal from the state on that?
Not from probation, Your Honor.
I'm sorry, I meant to say probation. I apologize. I said the state. And he has served, well, he was arrested on what date? Because I don't have that on my calendar.
Your Honor, he was originally booked on September 15th of 2022. He was released January 10th of 2023 for 118 days. And then he was rearrested August 5th of this year. And as of today, that would be 39 days. And that would be a total of 157 days on this charge.
All right, and do we, tell me, probation, do we know anything about the victim on this case? Is this the children's mother or what?
We do not have any information regarding the victim of it.
I will not revoke him and allow him to stay on probation. And give him a chance at this. So let's see what happens.
Your Honor, can we talk about the family violence program then? That's a 6 months course. He only has 3 months and 4 days left.
Oh. So what would you do? What would you recommend in that instance then?
Could we, Your Honor, if it's converted to 12 hours of anger management, I think he could do that within three months. And I'll provide him with information so he's clear on what's provided of him.
All right.
And then I will note for probation and the court, I'll fill out a updated contact sheet, but Mr. Moses does have that separate case still holding him, so we won't be able to report immediately.
Okay. So if we do the 12 hours anger management, I don't know if we should add any community service or not. I don't know if any was on the original case or not.
On the original case, Your Honor, it was just the FVIP class. I just want to make sure that Mr. Moses is set up to succeed. Again, I'm not sure when he will be able to bond out on these other charges. I know his family's working on it. But I'm not sure, I don't want to set him up for failure if he has anger management and community service waiting for him and he doesn't have time to adequately.
All right. I'll just go with the 12 hours of community service.
All right, Your Honor, can we do report within 48 hours upon release and enroll within 30 days?
Yes.
Hello, this is Darnell Cox.
Please do not speak, sir.
And Officer Allison, did you say enroll within how many days? I'm sorry, I want to make sure I convey it correctly.
Enroll within 30 days.
Thank you. And Mr. Moses, I will come see you so we are clear on what's required of you.
Position number 34 and 35, Mr. Rhodes.
Okay, and who are you, Mr. Cox?
Your Honor, he's on the DV
Yes,
bench
yes.
warrant calendar.
Yes, yes, ma'am.
Ford, this is your case.
Let me find my stuff.
And we just have his one case. We're trying to get to you, Mr. Cox. Hold on a little bit, okay? But I do see you there, all right?
Thank you. Can you hear me?
Yes, yes. Hold a little bit longer. We're getting to you, okay?
All right, thank you.
All right, thank you. All right, this is 34 and 35, Deputy.
Yes, Judge, thank you.
Okay. All right, 23 CR 004983C. Mr. Rhodes, you're charged with 1 count of criminal trespass in that first case from 2023. Second case 22 CR 003735C. Again, you're charged with giving false information to law enforcement, driving without a license, failure to maintain lane or improper lane change in 2021.
Yes, Your
And
Honor.
are these gonna be pleas or what are we doing?
Yes, Your Honor, the first, position 34 will be a negotiated plea. And position 35 would be non-negotiated. We're just challenging the fine, Your Honor.
Okay. All right, are these your cases, Ms. ASG Nimini?
Yes, Your Honor.
Okay.
For position 34, the state is asking for 12 months, 60 days to serve, credit for time served, 30 days, balance prorated, and a stay away from Georgia Tech campuses and buildings. So for the position 35, for count 1, the state is asking 12 months probated ballot, 12 months probation, balance suspended. Count 2, the 500 fine, and count 3, 12 months probation, balance suspended.
Yes, Your Honor, and on position 35, we're asking that count 2, that the fine be, my client has no money, no job at this time. He's been incarcerated, Your Honor, for over 30 days. And so that's why it's not negotiated. We asking that that fine be waived or lowered or at this time.
And can we convert it to what, 50 hours of community service?
Yes, we can.
Okay, yeah, my client said he'll agree to.
They're gonna come pick me up.
They're not gonna come pick you up. They're not gonna come pick you up. So if you're gonna do 50 hours of community service, you're gonna have to get yourself, find a program to go into and do the community service. Nobody's gonna come pick you up.
I don't know.
That's why, Your Honor, even the 50 hours of community service will be somewhat of a stretch for my client. He has no transportation, no ability to do that. That's why I was hoping the fine could be reduced to maybe $100 or $200, and he possibly could find a way to do 10 or 20 hours of community service.
Okay, so if we do $100 fine and 20 hours of community service.
You said both?
Well, oh, you were saying either or.
Either or, yes.
Well, I mean, if he can work and get somewhere, then maybe I'll, I don't know what his history is. Maybe I should hear that before deciding on how low to make the fine.
Okay. Yeah, I was just addressing, that's why we're asking for non-negotiated and 35, Your Honor. My client cannot pay.
Okay. Let me hear from pretrial and then I'll make a final ruling.
Our defendant has 4 arrest cycles beginning 2021. It looks like he has a possible open case with Georgia State University. That's for a simple battery. That arrest was March of 2022. No dispositions listed on the GCIC. And his last arrest, his most previous arrest was July 20th, 2022 by the Georgia World Congress Center Police Department for criminal trespass, disorderly conduct, cruelty to children in the 2nd degree. And there is no disposition listed for that case either. Nothing to add, Your Honor.
Okay. All right, so he doesn't have a terrible history at all. Doesn't sound like it anyway.
Judge Mason, did you see my chat?
Oh, okay, thank you. All right, I see that now. So I tell you what, I will lower that fine to $100. And I won't order any community service.
All right, thank you, Your Honor.
Okay.
$100. Well, you gotta find the $100.
So what is his credit for time service the count B.
Right. What are the dates that he's been in, Mr. Ford?
He's been in, Your Honor, 30 days. So he would be 30 days, credit for 30.
Okay. And I will, on this plea, I'm going to say that he can't drive unless he has a valid driver's license, no driving.
All right, Your Honor. So they're gonna find me the program? What kind of program?
All right, so are we ready on both, please?
Yes, we are, Your Honor.
All right, Mr. Rhodes, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
No.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
You're giving up and waiving the right to remain silent and not testify against yourself? Hello?
Yes, ma'am. You said yes.
Okay. Oh, okay, couldn't hear you. That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you to receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with a full understanding of the charges against you?
Yes, ma'am.
All right, I will accept your guilty plea to the criminal trespass. Remember, you are to stay away from Georgia Tech's campus. I think I heard something too about Georgia State with the other case. If you're not attending these colleges, you need to stay away from them. And make sure you do that or else you will be back down here. And on your second case, again, I've lowered that fine to $100 and no driving until you get a valid driver's license from DDS. So remember that. And you had a question?
No, ma'am.
Okay.
We're fine.
All right. All right. Good luck to you.
Oconee County, that's gonna be position 32.
Thanks.
For
Okay.
Oconee.
Yes, Your Honor. Your Honor, this is just, we're just moving, my client is pleading not guilty and we're waiving, arraignment.
All right.
In the reading of the accusation as well.
All right. Mr. Peak, this is 22 CR 001262J. Is that correct?
Hey.
All right. And that's Mr. Peak there in Oconee in the green.
Yes.
Okay. All right. So you understand that your attorney says you're waiving the formal reading of the accusations with your arraignment, and you're being formally charged by the Solicitor General's office with 1 count of battery family violence. And you've been formally accused by their office, by the Solicitor General's office. Just want to let you know again that this charge carries a maximum sentence of 1 year in jail and a maximum fine of $1,000 for this charge. Your case is going to be reset for a jury trial. That trial will be scheduled by the judge that it is assigned to in the division for the state court. That judge will set that case, and you'll get that information. Keep your address current. All right.
All right.
All right. Thank you.
You're welcome, Your Honor.
15 and 16, just to pray.
Okay.
I apologize. What position was the one that we just did?
32.
Thank you.
Your Honor, was it positions 15 and 16?
Yes.
Okay.
This is Mr.
This is Mr. Frazier.
Yeah, he's on jail.
Yeah.
Okay. You want to?
Gonna go next.
All right, Mr. Frazier is Dean Frazier. Here in 23 CR 00543G and 23 CR 00544G, 43G and 44G. The first case is theft by shoplifting, criminal trespass. Second case is loiter and prowling. Are they both pleased?
Yes, Your Honor, they're both pleased.
All right. State.
Yes, Your Honor. His first case, the state's recommendation is 12 months to serve, 32 days, credit for time served, 16 days. Balance probated with the conditions of an anti-theft course and stay away from the instant location. The address is 4947 Cottage Grove Place in Union City, Georgia.
Hi.
And in the second case, that would just be time served, balance suspended with the conditions of a stay away from 4960 Roosevelt Highway.
Okay.
And well, Your Honor, I have different addresses. My apologies for case for position ending in 243G. I have the Walmart at 4735 State Route 138. You have a different address, Mr. Walker?
Yes, I can double check that one more time.
Would you mind dropping the addresses in the chat if you can? I printed off all of his discovery. I may have gotten the addresses mixed up.
Okay, yes, I can put that in the chat.
Hey, if you could put both of them in the chat, we are clear on the locations. I think I just wrote the wrong ones. Got them mixed up. And Your Honor, this will be a negotiated plea, and we do stipulate to the factual basis, venue, and ID. We would just ask if Mr. Frazier's probation for position 15 could switch to non-reporting status upon completion of the anti-theft course. And if this court could cut him a break on probation fees, he currently does not have a stable address or employment. We want to make sure that he can afford that theft class and then do what's needed if ever.
Okay. I'll let him go non-reporting, but I cannot waive any of the probation fees.
Thank you, Your Honor.
Pick up the phone.
And then on the second case, that's just time served. Okay. And we were still checking the addresses, Mr. Walker.
Mr. Dodds had the correct address. It is the
Oh, okay.
Walmart on 138.
Okay. All right.
And then what was the address for the second case? I want to make sure I got that right as well, Mr. Walker.
1 second, I was reading directly from the one. Hold on.
Okay.
And there's several documents. Hold on.
I know I think we both got the same stack.
That's the 4947 Cottage Grove Place for the
That
second.
is correct. 4947 Cottage Grove Place.
Thank you.
All right, you ready on both, please?
Defense is ready, Your Honor.
Okay. All right, Mr. Frazier, raise your right hand for me. Affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury.
Yes, ma'am.
All right. Again, are you under the influence of any medication, unprescribed medication, drugs, or alcohol at this time?
No, ma'am.
All right. And are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
All right. Do you understand that if you're currently on probation, your probation could be affected by a guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the charges against you in both cases?
Yes, ma'am.
I will accept your guilty plea. You can go non-reporting in the first case, and please stay away from that Walmart.
Yes, ma'am.
All right, and then we won't see you back here again. Okay.
Yes, ma'am.
All right. Good luck to you.
Your Honor, position number 43. Mrs. Smith.
They're on 4 North.
Position number 43, Your Honor. And then if possible, after that, can we do 36? That'd be over with 4 North. Both of them for Mr. Ford.
Well, hold on. After you do your one, let me do my next one in courtroom 2.
Your Honor, this was, I think I put it down as non-negotiated because he would be 1 day short. He'd have to do 40 days, 45 days based on the state's recommendation. He has credit for 44. I was hoping that the state would go ahead and reduce it. So it'd be time served for Mr. Smith.
Okay.
Because if not, it'll be non-negotiated. I'll explain why he shouldn't do 1 more day.
I won't ask for the 1 more day. So it'll just be a time served.
Okay, thank you, Your Honor.
Okay. State, go ahead. This is 23 CR 004730J. Joshua Smith, charged with 1 count of criminal trespass, damage to property.
Yes, Your Honor. The state is asking 12 months, serve 90 days, credit for time.
Before she gets started, my client does have another case. Mr. Smith has another case that's 21 CR 000050J that I've heard that was scheduled for state all purpose on Thursday. I think that there should be a global resolution of this situation. So I was asked that if the state could, either we can hold this off until Thursday, because my client's not going to get out if he pleads today, and that way he can deal with both cases. If not, we just. Oh, you're not. Where's Mr. Smith at? Mr. Smith. That would be up to you too, Mr. Smith. Did you want to plead today and then wait till Thursday to plead to the other, or do you want to hear what both cases are going to be?
I would like to presume both cases today.
Okay, that's up to the state if they're prepared to do that. I did send an email out earlier.
The state is not prepared to provide a recommendation for the 21. Yeah, I haven't been able to look at the case yet.
Yeah, Mr. Smith, I did send an email out, but the state's not prepared to do that today. Did you want to wait till Thursday?
Yes.
Both cases?
Yes.
I do the one for the day.
You want to proceed with the one today?
Yes, sir.
Okay, I just wanted to make sure that you did have the right to possibly have a global on Thursday, but if you want to proceed, we're prepared to do that.
Oh, boy, he said a global.
You understand that?
I do the global Thursday.
All right, then.
Okay.
Your Honor, I think my client would like to wait till Thursday to have both his cases dealt with. I think.
Right. All right, we can do that, reset to Thursday.
Petition number 36, Mr. Robinson, that'll be last one for Lord.
Okay.
Will,
Hey, I'm trying to get out there. It's hot up here. Y'all got AC. It's hot. I love you too, but it's hot. I'm 360 pounds.
Okay. All right, we're starting, it's Jamie Robinson,
Yes, Your Honor. We're asking-
23 CR 005-239G. One count of willful obstruction of a law enforcement officer. Is this a plea?
No, it's not, Your Honor. We're asking for a bond hearing.
Okay. There's no bond set right now.
It's $1,000 surety bond, Your Honor.
All right, state.
Give me 1 second, Your Honor.
Okay.
Hello?
Okay. Okay. So Your Honor, this incident happened August 28th. Near a Texaco gas station. Officers arrived in reference to a trespassing call. He was called by the clerk who said that between 15 to 20 males were near the gas station, and it was after 2 o'clock, and I think it was around 2:30. As he was clearing the parking lot, he noticed 2 males. One is the accused, and another was an unknown male who fled in a vehicle. However, the officer was approaching the vehicle, and as he approached it, one of the individuals asked the officer to back up, and the officer noticed that there was a temporary Georgia tag that was incorrect. He ran the tag, and it came back for a red Nissan, but he was looking at a blue Kia Forte, and the unknown man approached the officer in an aggressive manner and asking why he was too close. And the officer told him that the tag was wrong. And that's when the person became irate. But then this is when the defendant came up and threw the keys to another individual, so that individual could get into the car, and then allowed 2 other individuals to get into the car. And then this is where the obstruction came from. Yeah, the state believes the 1,000 surety is more than enough. The officer was just investigating a vehicle that had the wrong tag, wrong vehicle information, and the defendant threw an unknown male the keys so he could flee from the vehicle. So the state does believe that this is more than reasonable, Your Honor.
All right, Mr. Ford.
Thank you, Your Honor. My client is 24 years old. He's a lifelong resident of Georgia. He does have lots of community support. He works for his uncle who is in the construction business. He has 1 child that's 2 years old. He has a stable address, Your Honor. You heard the facts of this case, Your Honor. My client is being held on obstruction, which is throwing keys to someone who didn't know if the vehicle was improperly tagged or anything. He was not instructed not to throw the keys, so that's not willful obstruction. My client wants to fight maintains his innocence in this case, Your Honor, but we ask that his bond be a signature bond at this time, Your Honor. He's got 1,000 surety bond for throwing the keys to someone. Your Honor, I just, at this point, I think he should have a signature bond based on his, the fact that he will not be fleeing. He wants to defend himself in this case. He spent 15 days in jail, Your Honor, on this. So we feel a signature bond would be appropriate at this time.
And Your Honor, I just want to put on record that, you know, he does have 5 cycles, and although none of them are violent or anything, the issue is he has an open FTA in Missouri. He has an open case in Florida. Yeah, considering that, I don't know if he's going to come back, considering he has 2 open cases in 2 different areas within the past 5 months. So we don't think a signature, a bond is proper, considering his chance to come back, because the one in Missouri is for a failure to appear.
And that was
there's 2 failure to appears, to my understanding.
right. And both of those in the last X number of years.
2 months.
2 months. Oh, wow. Okay, 2 months.
Yeah, I don't think
And he's wanted out of Florida.
and so I don't think he's a risk of flight, Your Honor. He's not gonna flee back. If she feels that he's wanted out of deported, I don't know if he's gonna flee there, but that's okay, Your Honor. I feel that based on the facts of this case, Your Honor, the fact that my client has done 16 days, a signature bond is what we're asking for.
Well, usually I don't give them with, I mean, those are not holes, they're just open. Are they holes?
The GCIC it does indicate a hold out of Orlando, Florida for a failure to appear. And that warrant was signed May 24th, 2023. It's just not showing on his jailing screen.
Okay. Now, I'm not inclined to give him a signature bond with that. That's very recent. When $1,000 surety, 10 or 20% is not a lot of money.
I have a number of clients, Your Honor, that tend to stay in jail or even on $1,000 surety bond. You don't have anybody who can put up $100, and I don't think, based on these facts, Your Honor, the fact that he's already done 16 days, I feel that a signature bond. My client is not looking to not deal with this case, Your Honor. You heard the facts.
What are his connections here in Georgia?
Your Honor, I have a Tavoya Daniels. It's a telephone number he gave me, and also he works for his uncle's construction company. So he has strong ties, and Your Honor, he's 24 years old, and he's lived in Georgia his entire life.
He's from Georgia. Okay.
Yes.
High school?
Your Honor, he did not complete high school.
Okay. Well, you know, I even hate to give a bond and run it through pretrial so that he can be reporting, because I do have a serious concern. I understand your point, but geez, just in May, you know, he got the other FTA, and when we're in September. And I know it may be minor, but he's already showing he doesn't have a history of showing back up.
In July, FTA, Missouri.
And the Missouri one was July, so.
Your Honor, you know, and here's the situation when it comes to finances. He may not have the finance. These 2 cases are in other states, Your Honor. He's probably trying to get the finances together so he can go to those states. So the FTA, I think, Your Honor, just a product of not having the proper funds, the proper funds.
Well, I'm just wondering when he gets out, how's he gonna get the proper funding? If he doesn't have any education, I don't know, construction job, I don't know, you know, he may end up. I guess he could let us know if he goes to the other states and they lock him up.
Your Honor, that's why we're asking for the signature line. Yes, I mean, he has no funding at this point.
Right?
And he's already served 16 days, Your Honor, which is the extent of this case.
My guy, you spoke to his phone, yeah. You spoke. And you spoke. That's one step back.
Have we talked to, and this stay away from this 808 McDonough Boulevard, what is that?
It's a Texaco gas station. It seems a bunch of people were staying there after the gas station had closed.
My client has no issue staying away from that location, Your Honor.
I was just seeing what kind of place it was and what about a victim of any sort, but it seems like there is not. And whose keys were they?
Your Honor, you know, they were the keys of his girlfriend. He doesn't drive. The person that asked for the keys was the person who was driving the vehicle. He was just holding the keys because it was his girlfriend's key, Your Honor, and that's why we have a real concern with the obstruction charge. He would not have known anything about the license plate or anything, and he was not even, presented with that information. So I don't, we're really concerned about the obstruction charge. So that's why we're asking for the signature bond, Your Honor.
I understand.
Yeah, and it looks like he has no bond on a felony unindicted case anyway.
Uh-oh.
But the,
Okay.
but the case is unindicted, Your Honor. That's why we're asking for the signature bond on this one. That case may not even be indicted.
That's in Fulton?
It is. He has no bond on it. The case number is 23 CP 215373. And it's for purchase, possession, manufacture, distribution, or sale of marijuana.
Okay.
Yeah.
Starting not to look good the more I listen to it, Mr. Ford.
Well, Your Honor, on that unindicted, he's gonna have to get a bond eventually on that, and we know that bond is not gonna be anything significant. So my case is, my thing is, my client will be out of jail as soon as a bond is set. I think I'm more so area.
I'm just concerned that if he's gonna show back up. Very concerned. Because he's been to the other two states and he didn't go back to those. And what's gonna make him come back to Georgia, especially if he knows he's going to jail?
Yeah, this is his home. This is where he lives, Your Honor. I don't think Georgia has an issue with him coming back to court. He's been here, this is where he lives, he's been here for 24 years.
Well, he's got a hold, so he's not going anywhere.
Yeah, Your Honor, I'm just concerned for the future that if that unindicted case goes away, that my client will still be sitting in jail.
And that's an if.
Well, yeah, that's an if, but I think it's a strong if based on the charges.
All right, I will grant a $3,000 SOB jail on this obstruction case. No drugs, alcohol, weapons, or guns while on bond. All right.
All right, thank you, Your Honor.
Position number 41 and 42, Mr. Smiley. Watson.
Yeah, we will.
Mr. Smiley, you still.
All right, what are these? Are these please 22 CR 008-228D and then the FTA?
Yes.
If this is Melvin Smiley, he's on probation 3 and 4.
Say that again, probation, I'm sorry.
If this is Melvin Smiley, he's on
Oh.
probation 3 and 4.
Yes, Your Honor, he is. I think Mr. McLean had dealt with the probation, but he has informed me that he has about a month and 6 days left on his probation. He has to complete a VIP course. Huh? Yeah, 1 month and 26 days, thank you. And he does have time to complete those courses. That's why we're asking that, that's why he's pleading today, Your Honor, so he can get out and make sure that we'd like to have his probation continued so he can go out and complete those courses.
But he's on both calendars. He also has a new case.
No, he has this case, Your Honor. He has the criminal trespass case, Your Honor.
Right.
And then he's up for a probation violation today. He's positioned, I think, 3 and 4. And he has a month and 26 days left on his probation. We were gonna ask for it to be continued, because I think he has to complete a victim impact panel. And what was the other course? Oh, yeah, risk reduction. And he could definitely get those done. But I talked with him, he said he could get those done.
Oh, yeah.
He can get those done,
I'm sorry,
and
Zach.
especially, and once he gets out of jail today, he'll go right at that and make sure that those are completed, so he will not be a violation of probation. Mr. McLean may want to talk about the probation a little more.
Right, Your Honor, the RR course, I believe, is something like 6 or 8 hours, if I'm not mistaken, so he can complete that. The VIP panel is a thing you watch, and it doesn't take more than an hour or two. I've never watched one, but I think it's costs about $100, something like that, sometimes less. An evaluation could be done within an hour, and that I've seen advertised for credible providers of rehab services for under $100 just to get an evaluation on alcoholism and drug addiction. So the two things, VIP and ADET, are pretty short and pretty reasonably priced that he can get out there and get that done. The risk reduction is going to be a little bit harder, but he can get that done certainly within a month and 26 days.
And Your Honor, and that's our reason for a non-negotiated plea today, is because, thank you, Mr. McLean. That's our reason for a non-negotiated plea, because based on the state's recommendation, he's scheduled to do 45 days, credit for 18. That would make him 5 days shy of time served. So we'd like to see if he could get out of jail and make sure that he doesn't use up 5 days of the time he can use to complete his probation.
What do you say, probation?
Mr. Smiley has a court fine of $1,285. He did not report, of course, 2 times while he was on a probation revocation hearing for May 23rd, which he did not appear for. He does have to complete the risk reduction, victim impact panel, drug and alcohol evaluation, and also 240 hours of community service. With him only having 1 month and 26 days left, probation recommends to revoke that risk reduction program. It is a little difficult to get into sometimes. We do see that it takes about a month or 2 to get in by itself, with them getting filled up in the amount of time. And then with the amount of hours for community service, he has to complete the 240 hours.
That's all
Right.
I didn't know.
You know, I might mention that he did have a death in the family It wasn't right away when he got on probation. We're not trying to make an excuse out of that, but he did have some depression when his sister died later on. I believe there was an illness leading up to that.
But you know, we always tell them to call in and inform them. You know, let them know, let probation know what's going on. Just don't disappear, because then you end up back here at the Fulton County Jail, and then he picked up another case. Because that was in 21, and then he picked up the new charges in 22. And then FTA in 23. So that's almost 2 years. A little over 2 years that he's had to do all this. What's his history like?
Mr. Smiley, he has 69 arrest cycles beginning in 1984. His history within 10 years, he does have a misdemeanor conviction out of Fulton County for battery family violence. That was from February 2014. He has another misdemeanor conviction for a criminal trespass, August of 2016. Marijuana possession less than 1 ounce, December 2019. Another criminal trespass, August of 2022, and a willful obstruction. It looks like he has a possible pending case out of DeKalb County for disorderly conduct and criminal trespass. That arrest date was August 12th of 2023. He has let's see, 2 violations of probation, 2 FTAs, and he has 3 cycles out of South Carolina. One of them was a misdemeanor conviction for public drunk, and his last arrest was October of 2021 for public disorderly conduct, and that resulted in a misdemeanor conviction also. Nothing to add, Your Honor.
All right. That makes it a little different for me, Mr. Ford.
Your Honor, that was a probation violation, Your Honor, but on the position 41, Your Honor, we're just asking, he's going to plead to that, and we're just asking for it be time served versus him having to do, hold on, I had it right here, okay.
On the DUI?
Yeah, no, not on the DUI, I'm only here on the criminal trespass, Your Honor. Mr. McLean was handling the probation violation on the DUI. I'm handling the criminal trespass, which is going to be a non-negotiated plea. We're asking that it be time served, that he not serve the additional 5 days recommended by the state.
Okay. State have anything to say on the criminal trespass?
We want him to carry out the last 5 days.
Okay. And that's with MARTA?
Yes, it is, Your Honor.
And I didn't hear the facts on that, did I? ASG Nimini?
No, Your Honor, give me 1 second.
Okay.
Yes, sir. Yes, sir. Yes, sir. Yes, sir. Yes, sir. He put us in the. Yes, sir. So, you know, this is, we can deal with the
Oh, it looks like he just entered, MARTA with an active suspension. And then he knew, yeah, so he went through the College Park train station, the fare gate, and he walked on the platform, and the officers arrested him and asked him if he knew that he was suspended. And there was a 365-day suspension effective January 1st of 2022 for him to resume the second, February 12th of 2023. And then he had also had a pending 60-day suspension that was given November 13th of 2022 to resume riding May of 2023. However, the incident occurred within a month of after he got his first suspension. Yeah. And it's from my understanding, there's a lot of criminal trespasses with MARTA. And just like the 5 years, let me pull up.
Right.
In the 5 years, I have 23 from 2015, 2 from 2019, 2 from 2022, 2021. The state doesn't believe 5 days is that detrimental, Your Honor.
Okay. On the plea, I mean, with his history, I would say that he needs to serve the 5 days and hopefully he will stop at some point. So I'm not inclined to waive the 5 days, Mr. Ford.
Okay. Mr. Smiley, the judge is saying that you're gonna have to do the 45 days recommended by the state, which is only 23, and then you have to do an extra 5 days, okay? Extra 5 days.
5 more days?
Yeah. You okay? Yeah. He's okay with that, you know.
Okay. All right, so we'll take the plea in that, and then on these probation violations, they're asking, make sure I'm sure with probation.
No.
On the case with probation, you were asking to revoke him, correct?
Yes, Your Honor.
And he would have to serve, I didn't write down, how many more days?
61 days.
No. No.
Would it be over? Everything.
Correct, John. It'd be somewhere in the neighborhood of 56 to 61 days, depending on how many months, how many days in a particular month. Your Honor, we recognize the 240 hours of community service would be impossible to get in. That is unfortunate, but as a practical matter, we would be asking the court for a complete buy on that. Just give him a break. But he could sure try to get that RR done if he could get out free. And the VIP and the ADE.
He can do those? The ADET and the VIP and the R&R, do those?
He can do those 3 things, Your Honor.
And then, what about the $1,285?
He's pretty broke, but he does have a brother, I believe, that's gonna help him financially. How much financial help that brother can give him, I'm not sure. So that's family and they love him. They're gonna try.
I hope they love him. He has an alarming history, though.
I can see it. Okay.
I'm making him do the 5 days on the other case. Probation, it was something I was going to ask. On this one, with the 61 days. If I don't revoke him, then he's got to do all the other conditions. I'll take off the community service.
Thank you, Your Honor.
Okay.
Yeah, and we to ask on the criminal trespass that all his probation fees be waived.
I'll just waive 6 months.
I apologize, but what is he doing while he's on probation? I don't see it.
The
Does
probation.
he have to, sorry.
Go ahead.
That's what I was gonna ask. Does he still have to do the 3 classes and then you're just taking off the community service?
Right.
So then he also has to pay the fine still.
Right.
Okay.
Right. That is correct. Isn't that your understanding too?
Yes.
Okay.
And Your Honor, and after he, I see that his balance is probated, even though that there's no conditions on the criminal trespass. Is there any way for that to be?
That's what I was asking. Is it a balance suspended or is a balance probated? There is no condition.
Balance suspended, and then that way he could have to observe any of the martyr suspensions.
Right. Yeah. That's contradictory. So it would be suspended. You're right, Ms. Strong.
Okay.
But you're not to go back to MARTA. Mr. Smiley, get some ride shares or
Yes,
get a
ma'am.
bicycle. Do not go back to MARTA.
Yes, ma'am. As long as there's no suspension, right? Am I correct, Your Honor?
Well, it says if it's any active suspensions, if it's not, I just wanted to double check that there's no active suspensions.
Thank you. Thank you. Yeah, so you can't go back if there's no suspension. Right.
But even if you do go back without suspensions, be careful because people
Yes,
tend to go
ma'am.
back and get right back in the same situation.
Yes,
So I'm
ma'am.
just saying,
Yes,
be
Your Honor.
cautious
Yes, ma'am.
because if they see you, they're going to be watching you.
Yes, ma'am.
All right. Anything else? I guess I need to take your plea real quick. Raise your right hand for me. Do you affirm the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down. Are you under the present influence of any unprescribed medications, drugs, or alcohol?
No, ma'am.
You satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Yes, ma'am.
You're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
You're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you receive a lesser sentence for pleading guilty?
No, ma'am.
And you understand that if you're currently on probation, it could be affected by this guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right. And so I will accept your plea to the criminal trespass and the balance suspended. And you've got to serve the 5 days.
Yes, ma'am. Yes, ma'am.
Okay. All right. Anything else, State, that I've left off?
I know, Your Honor.
I know. I was making sure because didn't mean to take so long. Sorry about that.
No, you just, I should have told you. That's okay.
Position number 31.
Thank you. Good luck to you.
Thank you, sir. Thank you.
Mike?
Thank you, sir. Thank you.
Mike?
Mark.
That's 31's name. No, but no.
Thank you, Mike. Thank you.
All right, this is 23 CR 005203J. Lionel Nephew. Is this a plea?
Your Honor, this is a plea of not guilty. It's an arraignment. He does have a hold on him for Liberty County, which is on the coast of Georgia, near Fort Stewart. That's where he substantially grew up, Your Honor. And because the bond on the matter on which we're pleading not guilty today, the bond is $500 for 1 count of disorderly conduct, $500 for 1 count of willful obstruction. We're going to ask the court to consider a signature bond on that, Your Honor. We believe the family will be able to contact Liberty County. We think there's actually a chance Liberty County matter is quite minor, and that might even be dropped before they even would think about picking him up. So Liberty County is not going to be a big shock to his life. If they do pick him up, it's going to be a minor matter and be over with pretty quickly. on this particular matter in which we're charged with in Fulton County, it did not happen that way, and he intends to vigorously defend it. Unfortunately, Your Honor, in the jail, he was jumped and his jaw is in terrible shape, quite swollen. I fear for injury because once you're injured like that, it wouldn't take much of a hit to make it far, far, far worse. I'd love to get him out of this situation now, if a signature bond could be had. And the main argument for the signature bond is that this started off as some kind of dispute over $1 of change, a hair on the sandwich, and the store staff being mad about being asked to refund it. And we believe that the store staff was very exaggerating and not making a call. This was, the police never should have been called over something like this, Your Honor. And the obstruction, he's simply charged with running, and he was in fear at that moment. He heard a noise, seemed like a click, and he just wanted to get out of there. And so that's not going to be a willful obstruction, in our opinion. The state, of course, will disagree.
Your Honor, the state's gonna ask pretrial to read his criminal history.
Okay. Pre-trial.
Bennett has 14 arrest cycles beginning in 2017. He has a misdemeanor conviction out of Clayton County for simple battery family violence. Let's see, that's from June of 2018. He received first offender treatment on that case, and it was revoked October of 2018. He has another misdemeanor case out of Clayton County for criminal trespass. Same disposition date, June of 2018. We have a simple battery out of Henry County. And that's from May of 2019. We have a criminal trespass, 2 counts of criminal trespass out of Clayton County. Disposition date on that is September 2019. We have another battery out of Clayton County, September 2019. I have a disorderly conduct out of Long County, November 2021. I have a felony conviction out of Liberty County for willful obstruction of law enforcement officer, resisting obstruction, opposing law enforcement officer on duty with animal crossing. Let's see, I'm sorry, not crossing. Okay, those 2 charges, disposition date on that is December 2021. He's on probation for 5 years on that case. Let's see, he has 2 FTAs and 2 violations of probation. And the GCIC does indicate a hold for Hinesville for a probation violation. Date on that warrant is March 27th, 2023. Nothing to add, Your Honor.
Okay.
Right, Hinesville is that Fort Stewart area.
Mm-hmm.
So, Your Honor, this incident happened August 25th of this year at 2701 Metropolitan Parkway Southwest, also known as the Burger King. Officers were contacted by the manager, who advised that defendant had came into the restaurant, made a disturbance, upset about his order. She attempted to correct it by giving him his money back. He was still unhappy and told her that she needed to give him a drink for his troubles. She told him that she was sorry, but she was not going to be told what to do. Officers were shown video footage, and you can see defendant take his money and leave, and then return back to the location later with his shirt off, coming back through the door in an aggressive manner, trying to force his way in. And that's when he reached into his bag after encounter as if he was going to grab a firearm. And then when officers arrived at the location, they met him in the parking lot with the basketball in his hand and a book bag on. They told him to drop his things and get on the ground. And that's when he looked at the officers and took off running down Cleveland Avenue. Considering the criminal history, considering the arrest, the parole violations, the failure to appear, the state believes that the 500 for each count is more than reasonable, Your Honor.
Okay.
Right, he certainly had no weapon, Your Honor, and didn't mean to appear in any kind of way like he was reaching for one. Because considering the day, it was quite hot out, so it wouldn't be unusual to be shirtless.
But I mean, to
On
do
a
all
shirt
that over,
prior to- He had a shirt on prior to
Correct.
his first incident. And then when he left and came back in an aggressive manner, that's when his shirt was off. And the state isn't stating that he had a gun, but he reached into his manner, acting irate. These days, you
over
never
a
know.
hamburger.
Yeah, over a hamburger.
And he's been in how long, Mr. McLean?
Let's see, the end date, that.
I have 18 days today.
That's correct.
18.
That is correct, 18 days today.
And tell me, go ahead, Mr. McLean, give me the background on Mr. Nephew, his age, and I think you said he from Georgia.
He substantially grew up down there in that county, Long County.
Oh, that's right, down in,
And
okay.
I believe he's, let's see, I was looking at he's a young man. He's not, was born in 1999, so he's 24 years old this month. And he is energetic and employable and doesn't have a problem getting a job. This was an unfortunate incident, Your Honor, but he is certainly a contributor to society. An anger awareness class wouldn't be out of order if we could go that route.
But is he working?
Currently, I don't have him shown as working, but he does have prospects.
Okay. Because that's my concern. You get out, you don't have any money. He's waving his hand. Maybe he'll tell us real quick just to answer that one question about working.
I think he will, Your Honor.
Okay.
Mr. Nephew, are you working right now?
Yes, sir. I have my own lawn care business.
He said he has a lawn care business.
His lawn care business is ongoing. I'm flipping to my notes. He does not have employees in the lawn care business. He has himself, but it is it's sustaining him, Your Honor.
Mm-hmm.
There's a fair amount of business out there right now, and the injury to his jaw won't prevent that because of where it's located.
Okay. I'm just concerned there's so much anger out here over little things. Just don't want him to blow up into bigger things. And he's been in, and tell me again how many days he's been in.
18.
18. I'm going to give him a $4,000 signature bond. And I'm going to do this through pretrial per the judge, because I still want him to be monitored. That's $2,000 on each of the charges. Ms. Strong. And with that $4,000 signature bond through pretrial, he needs to report, and he can take the anger management course through pretrial. No drugs, alcohol, weapons, or guns while on bond. And then they'll monitor him. They'll have to report into pretrial.
I think they call it a anger awareness class.
Anger awareness, Okay, you could take that through pretrial.
Mr. McLean, do you have a phone number for him?
Let's see. I have a phone number for his mom. I don't have his phone number.
Can you send it to me, either put it in the chat, or you can email it to me, doesn't matter.
Okay. Oh, no. I'll find it. No problem. I'll need the phone number for him. I do need to, I need to do it on work, on my attention. Not that. Thanks.
Is that it?
That's it, Your Honor.
Okay.
But we do need to, I waive the formal reading of the accusations on the 2 counts, and the court will just simply make him aware that he will have future court dates to be aware of, and the maximum punishment for each one, of course, is the misdemeanor punishment level.
Right. You've been formally charged, Mr. Nephew, with the 2 charges, disorderly conduct and willful obstruction. Each of those charges have been formally accused by the Solicitor General's office, and each carries a maximum sentence of 1 year in jail and up to $1,000 fine for each. You've been formally notified of those charges. Keep your information, your contact information updated with your attorney and with the court clerk so that you will know about your dates to return to court and you won't be an FTA. So you've been formally arraigned and it will be assigned to the division judge. The cases will to be set for trial, okay? All right,
Thank you, Your Honor.
all right.
Okay, I'm gonna put, Ms. Waru for this 786. Okay.
Good afternoon, Your Honor. This is ACDC.
Yes.
Miss Position 7 and 8, Margaret Waru. Come on up, Miss Waru. Have a seat. And after her is Position 48, Miss Alana Vasquez. And if you need to speak with them, Your Honor, I will have to unmute it.
Okay. This is on the probation revocation.
Margaret is on probation 7 and 8, Your Honor.
All right, I forwarded that to me, but I don't see it. So hold on a second. I have to open it.
Oh, I got 5 and 6. That's okay. I got my start. If you look at the probation, my
Yeah,
probation,
7 and 8. I don't think any of us had the updated calendar.
okay, because I have 5 and 6 for Ms. Barber.
Exactly, right. That's all we have. No, there's an updated one with them being, with her being 7 and 8.
Okay,
I can
Check
send it
your
to you,
email
Your Honor.
again. I just sent it to your email again.
Okay.
Should be on the top now.
Okay. Yeah, because I have a lot of emails, so. So we've got 23 CR 002956H, one count of PI. And then we have the second case, 23 PV, which is the FTA for that case. Okay. Probation.
Yes, Ms. Margaret did not report June 16th of 2023, June 23rd of 2023, or July 14th, 2023. She has to complete a drug and alcohol evaluation. She has 8 months and 14 days left. Probation is recommended to continue on probation, report within 48 hours, and to complete the drug and alcohol evaluation within 30 days.
All right.
Your Honor, I've spoken to Ms. Waru, and she has no, she will have no problem completing the condition of the alcohol drug evaluation and treatment. It's just, she was sentenced on May 30th, Your Honor, and the first day that she was considered to be violated was like, I think, 2 weeks later. So, Your Honor, I think Ms. Waru understands that she has to complete that condition, and she will be done with her sentence.
All right. And she has how much time left again, Ms. Allison?
8 months and 14 days left.
She has 8.5 months, 8.5 months, Your Honor. I think she can complete that with no problem.
Okay. All right, I will continue her on probation. I will not revoke her. Anything else?
No, Your Honor, other than, I have her notice, we'll just send that into you, Your Honor, for your signature.
You have what now?
Yep. Yep. I said, we'll just send it for your signature, Your Honor. The recommendation. I guess you've already been signed. Oh, okay, yes. Fine.
Your Honor, are you agreeing with completing the drug and alcohol evaluation within 30 days?
Yes.
Okay, thank you.
All right, I think that concludes her cases, correct?
Yes.
Okay. What do we have next?
Your Honor, I know we're still waiting on this, Patricia Douglas, positions 11 and 12 at ACDC, if she's ready.
Yeah, Lopez as well.
Your Honor, I was told position 47, Ms. Vasquez is ready. She's direct at South Annex 2.
All right. 37 are you?
All right, this is Miss, is it Alana Vasquez? Yes. All right. In 23 CR 0052226J, charged with obscured or missing license plate, possession of dangerous drugs, and possession of multiple driver's license.
Yes, Your Honor. This will be a bond hearing, bond reduction, bond modification.
All right. Mr. Go first, state, or no, you, Mr. Ford, go first. For your
Okay.
bond modification.
Yes, Your Honor, my client is 35 years old. She has spent the last 17 days incarcerated. She is a high school graduate. She has a college. She's a medical assistant program for 2 years. She works at Southside Medical. Your Honor, she has, well, she's not working now because of this issue here, but she's hoping to get her job back. Your Honor, she has 3 children, 2 girls, one 13, and a boy that's 14 that she's the sole provider for. She is she's a resident of Georgia her entire life. She has a stable address, Your Honor, and I also have, she has community support. I do have a telephone number for Miss Allen, which is her aunt. I have her telephone number and her email address, Your Honor. We're asking for a signature bond due to the fact that she has worked for, she has been incarcerated for the last 17 days. And it's been a struggle because she is the supporter of her 3 children. She needs to get out so she can tend to them. Your Honor, the facts of this case was the fact that she had an obscure license plate. They said it because the license was in her window. Also, they found a duplicate license on her, where she had lost her license when you got a second one, but then she found the other one. And Your Honor, there was some illegal drugs or some drugs that were not hers, but Your Honor, she had a friend who had left them in the car who had a proper prescription for them. So Your Honor, at this point, based on the facts of the case and the fact that my client has spent 17 days in jail, she's needed at home to support her children, which one is 2 years old, Your Honor. We ask that her $3,000 bond, surety bond, which is $1,000 on each count, be reduced to a signature bond, Your Honor.
All right. State.
Yes, Your Honor. So this incident happened August 27th. It was a traffic stop because of the officer couldn't read her plates because they were obscured. That was the initial stop. He asked her to step out of the vehicle. Her behavior was off, as if she was attempting to distance herself from the vehicle. When asked to enter, she went to the rear passenger side instead of the front driver's side, in which she had currently been, which is odd behavior. Her ID showed that she had a warrant for a probation violation. However, while the officers were inventorying the vehicle in preparation for getting it towed, they found 4.8 grams of 16 pills of trozonin, 13 of which were located in the baby seat behind the passenger seat, where she, after she stepped out of the vehicle and was asked to return to the vehicle where she went to, not the passenger side. I mean, not the driver's side that she initially was, but she went to the side where the baby seat was located. And then the defendant stated that her child must have gotten into the pills, and then her friend attempted to corroborate the story. However, in that moment, at that time, none of their stories matched up to the officers. I would like pretrial to read her criminal history because I do know she has 3 open cases. 1 simple battery, criminal trespass, criminal damage to property, another one criminal damage to property, another parole violation. We have a 2007 ag assault, 2012 criminal damage to property, 2nd degree, 2015 hit and run, 2017 fraud and deposit. The state believes that the $3,000 bond is more than reasonable considering the possession of the drugs and where it was located. So the state is asking for you to keep bond as it is set.
All right. And again, that's $3,000 surety.
Yes, Your Honor, we're asking for it to be a signature bond. And like I said, she has been incarcerated for 17 days, Your Honor, as well. And like I said, she does have the three children, one of 2 of it years of age. And like I said, she was working as a medical assistant. She's hoping to retrieve that job once she gets out of jail.
All right, and she has 3 open cases. That's what I'm concerned about. Pre-trial, how many cycles total, Ms. Astor?
She has 11 cycles total, beginning in 2007. Do you want me to read the rest of the history too?
That's the current. I won't go back to 07.
Yeah. She has a felony conviction out of Fulton County for aggravated assault and hit and run duty of driver to stop or return to the scene. That was from, let's see, January of 2016. She has another felony conviction out of DeKalb County for deposit account fraud, bad checks. That's from May of 2017. The open case for the criminal damage to property in the 2nd degree. And her last arrest was in Fulton County, March 3rd of 2023 for simple battery, criminal trespass, and criminal damage to property in the 2nd degree. She has two violations of probation. And the GCIC, as well as her jailing screen, shows that she has a hold for probation.
Hello, this is Darnell Cox.
Whoever's speaking, be careful and mute yourself.
Nothing to add, Your Honor.
All right. All right, I will, well, I don't think a $3,000 bond is unreasonable. Certainly, and I do understand the open cases alarm me and the number of cycles alarm me. So, I will modify it to a $2,000 surety bond. And that'll be $500 on the license plate, $1,000 on the dangerous drugs, and then $500 on the multiple license. So it should be a total of $2,000 surety bond. So I will just decrease it by $1,000. So it'll be a $2,000 surety bond. No drugs, alcohol, weapons, or guns while on bond. All right. You have that, Ms. Strong?
Yes, ma'am.
All right, next case.
Position 20 and 21, let Mr. Harvey.
CR 004942J, Thomas Harvey. 2 counts of simple battery, family violence, no, 3 counts. And then 1 count of disorderly conduct. And the FTA.
You said got 3 counts of family violence?
I'm sorry.
I misunderstood the charge to you, man.
Your Honor, it turns out Mr. Harvey does have a probation hold. And for that reason, I could ask the court to, considering the time that it is, I would have the chance to talk with him further if we were to reset this 2 days or 7 days.
Mr. McLean, you may want to do him today because it was hard getting him up here. He had a long way to walk. He's on a walker. You may want to deal with this case today because the next go round we may not be able to get him out.
I would need a breakout room with him, Your Honor. I did speak with him yesterday, but we were cut short. And I would need to explain one more thing to him. So breakout room would be appropriate.
All right. I have to just see at 2 o'clock, so we need to move this along.
Will Mr. McLean be on the breakout room with Mr. Dotis' laptop?
Yeah. That would be Mr. Dose's laptop. All right. I don't know. You want to do it? This is definitely right. But one of them. And
Excuse me, Judge, we still have the DB case that's, that we haven't went over. If you guys want to go ahead and do that case.
All right, thank you. We'll do that.
Well, after he had his last outburst, I don't see him on anymore.
I placed them in the breakout in the
Oh,
waiting
okay.
room.
Okay, thank you.
Thank you.
Your
Yeah,
Honor, I still have position 45, 46, 45, 46. Vicky Thomas.
can we do that one DV case, please?
Your Honor, that is Attorney McLean, so I need to go grab him.
But Your Honor, I just want to find out what happened to position 45 and 46, Vicky Thomas. She was in ACDC.
I have no idea.
Mr. Forbes, who are you trying to reach at ACDC?
Vicky Thomas, position 45 and 46.
One second while I check for you.
Okay, thank you.
Give me a few minutes and I'll bring her around.
All right.
Your Honor, did we also do, I can't remember position, what was it, 11 and 12, Ms. Douglas? She's at ACDC as well. Did we address that case? That was Attorney McLean's, but if, I want to make sure Officer Milton is bringing both of them if needed.
Yeah, we didn't do that one either.
What's her? Okay, what's the name for that one?
Patricia Douglas. And you said McLean has Darnell Cox?
Yes, Your Honor. I let him know that we're waiting for him, so hopefully the breakout room will.
Yes, ma'am.
Resolve.
Yes.
shortly. I know Mr. Cox has been here and has been patient.
This is
Hold
me.
on, Mr. Cox. We're trying to get to you. Just hold on.
Can you hear me?
We can hear you. Hold on a second. To wait till the public defender comes back out of the breakout, and then we'll do you next. Okay?
He's here. Attorney McLean. Mike, did you speak with Douglas?
Mr. McLean, can we do this one DV case?
Yes, Your Honor.
Darnell Cox?
I spoke with Mr. Cox by phone this morning, just prior to court, about 8:45.
Uh-huh.
And he explained to me, Your Honor probably knows the expression being caught flat-footed. He regrets that his mailing address was inadequate at the time he would have gotten notice. He has good, stable mailing address now and asked the court for a break on that because he intends not to ever miss a court date. He didn't do this on purpose, but he realizes that that mailing address was the problem. And he and I discussed that that is his responsibility. In addition, Your Honor, I did mention to him that a person should never, even when the mailing address is correct, and I'm not trying to reflect onto another topic now, but this is important for him to hear too, because it's a repetition of what he and I discussed in the parking lot. Well, I was in the parking lot, he's at home. A person can go down every 2 weeks to the clerk's office in person. They have a computer there on the desk, the counter, opposite the windows where you tap to get their attention. You don't even have to bother the clerk to look up your own name. If you do that every 2 weeks in person, you'll never miss a court date. You don't have to rely upon the full daily report. You don't have to rely upon the mail. So when a person is in danger of losing their freedom, I sure wouldn't trust my freedom to U.S. mail, even though we love the postal workers. I would go down in person. And he understands my point, he told me. So, Your Honor, I would ask the court to give him a break. He's updated his, of course, when he obtained this hearing, Your Honor, of course, he updated his address at that time.
Well, we have a few problems, Your Honor. First, as you know, it's the defendant's responsibility to update their address and make it to all court appearances. I have checked Odyssey. I hear that counsel is asserting that it was an insufficient address. Unless I'm not seeing something on Odyssey, I see no return to sender. But let's just back this up a little bit. The defendant was given a surety bond back in January of last year. This is not his first FTA with Judge Richardson. He initially FTA'd on March 7th of 2022. A bench warrant was issued. About 3 months later, he was picked up on that bench warrant from Judge Richardson, along with some other warrants. He did eventually make another bond on that bench warrant, and he subsequently bench warranted yet again on July 24th, which was a trial calendar in front of Judge Richardson. He had representation, and he had previously been granted a resit prior to that FTA. So because this is not his first FTA, this is his second FTA, he was actually picked up on the first bench warrant. And additionally, he's wanted currently from multiple jurisdictions. He's also wanted, he has an active probation warrant out of Fulton County as we speak. And I also contacted the city of Atlanta, and he's in bench warrant status over there, is wanted out of the city of Atlanta as well. So seeing how this is not the only warrant that he currently has at this time, the state could not in good faith or good conscience consent to the bench warrant being set aside. We are asking that he is remanded into custody on this bench warrant, and a new bond amount of $6,000 surety is posted. I believe that's the bond that has been set in relation to the bench warrant issued by Judge Richardson. And again, he currently has an active probation warrant that also is in Odyssey, and he's wanted out of the city of Atlanta for our FTA. So we're just asking that he turns himself into the sheriff's office at 901 Wright Street.
And Your Honor, if since that sounds like quite a bit of fish to fry, Your Honor, if the court were inclined to have him turn himself into Wright Street, we would certainly ask the court to consider not doing that. But if the court did that, we'd ask for a signature bond. It's got other matters to take.
What's his history?
It's
Mr.
pre-trial.
Walker.
I saw
Are
27
you on pre-trial?
cycles. Yeah,
How many?
I saw 27 cycles. I think
Okay.
the last was like, well, for the cases that he's actually showed up on and not FTA'd, I think the last I was shown was a 2020 DUI conviction. But I'll live pre-trial.
Yeah, that is correct. Yeah, I have the same information, 27 cycles. Let's see, first cycle began in 2005. So history within 10 years. He has a misdemeanor theft by taking out of DeKalb County, January 2014, misdemeanor simple battery, November 2014. Let's see. Theft by shoplifting out of Chamblee, May 2015. Another theft by shoplifting out of Gwinnett County, January 2016. A theft by taking out of Douglas County, February 2016.
Can I speak?
Not yet.
Driving while license suspended or revoked out of DeKalb County. That was September of 2018. He took a NOLO plea on that case. And knowingly driving motor vehicle on suspended or canceled revoked registration. Another theft by shoplifting out of DeKalb County, May of 2019. A DUI out of DeKalb County, February 2020. The last arrest was March 20th of 2023 for marijuana possession less than 1 ounce and possession of cocaine. And that was by Georgia State University Police Department. He does have at least 3 violations of probation, and I did see 2 prior FTAs within the last 10 years.
And Your Honor, I'm sorry, I'll admit it, he has, since the inception of this case, he was arrested here in Fulton County for reckless conduct. I do have that case number, which is now a conviction. That looks like it's from July of last year, 22 CR 004719F. And his initial bond in the case is before the court. Currently, it was a no weapons, drugs, or alcohol. I bring your attention to that reckless conduct case because it is drug related. I believe it's about 3 or 4 counts of reckless conduct where his children consume his edible THC gummies, and he was found with 3 grams of marijuana on his person. Search incident to arrest. That has been a conviction. So outside of the FTAs, outside of him being wanted from City of Atlanta, probation violation, that's a warrant. Previously FTA on this case and being arrested on the bench warrant, now a second FTA. The state has grave concern for likelihood of reoffending, safety for the victim. He has violated his bond. Again, there was a no drugs provision in his initial bond. I hear that he's been arrested for marijuana and cocaine, and we do have a reckless conduct conviction. This defendant has been given multiple chances, and he has simply not come to court, not just here. It sounds like he hasn't reported to probation here, and it sounds like he has not been to the City of Atlanta court either, and that's why he has an FTA and a bench warrant there as well. So we will be objecting to any signature
Can
the bond
I speak, Judge?
has put in place to remain as said.
Can I speak?
I would
Mr. Cox, you have an attorney. Let your attorney speak for you before you say something against your interests that will not help your case. You have Mr. McLean representing you, so allow him to speak for you.
I didn't even know who's my attorney. My attorney got switched several times.
Okay, well, it's Mr. McLean, and you see him in courtroom 2. That's your attorney. So let him speak for you. I suggest you be careful.
Yes, ma'am. I understand. I understand. I was on probation. I was on probation.
Please be quiet and let your attorney speak for you first before you make it worse for yourself. All right, go ahead, Mr. McLean.
Principal, Your Honor, I would point out that while there are 27 cycles there, the majority of them do have some age on them, and we're back in 2005 and 2014 and 2016 and that sort of thing. Your Honor, the state did mention some that are more recent. I would point out there's quote only 1 DUI, and that's a good thing. I'm not he's not offering any excuse about the reckless conduct, but he's just asking the court to consider that any FTAs he's had in the past would not occur again. He's determined to be available, and he did, of course, although he told me he'd never Zoomed before, he got the advice from somebody on how to do it correctly and was able to Zoom in today. I'm very proud of him for that.
How many, I think, and remanding to Rice Street, he has how much time left?
Are you speaking to the probation matter? That I'm not certain.
Oh, yeah, don't know.
I'm just showing the warrant Odyssey that is active. I believe it's a case. I was trying to look it up. I could not find it, but I know the warrant is active because it's showing, I think it's related to a Judge Besson case.
Okay.
Yeah, I just can't speak to that because I haven't seen it, but
and that was issued June 21st of this year.
I would just ask the court to consider that even as to a probation violation, and certainly as to any case, he's innocent until proven guilty, and even on the violation, we haven't proved the violation yet. So,
well, the list is too long here. His history is too long, too troubling to me. I don't know what's going on, but not with this kind of history and this kind of record would I consider allowing him to continue. So I would issue the warrant and ask him to turn himself in to the Sheriff's Department at 901 Rice Street and I remand him. And it's a $6,000 surety bond.
That is my understanding, Your Honor. And is that amount because he has previously FTA? This started out as a $3,000 surety, and then
then
on
usually
the
it
first
doubles.
FTA it would double to a 6,000, and now he's
Mhm.
FTA'd again. I mean,
Oh.
lucky for him, they didn't double it a second time, but it's still at a
Right.
6,000.
Right, yeah, it would have to be the 6,000 at least. And so that's what I'm going to order. I've heard quite a bit, trying to move along a little bit here, but I'm going to remand him. So he needs to turn himself in, or they'll pick him up eventually.
And I would ask that he turns himself in within 24 hours, Your Honor.
Yes.
So can we put a day, a time? I know, I'm sorry, Mr. Walker, you said within 24 hours. Can we put a time so that we can put it on the bond order? We don't want to leave it up to him to turn his within 24 hours.
I will let counsel select the time within 24 hours if that's okay.
By 1:30 tomorrow. 1:30 p.m. tomorrow.
That's fine with the state, Your Honor.
Okay. So, Mr. Cox, you have until 1:30 tomorrow. Turn yourself into Rice Street. All right.
Okay, can I speak? Want to say something?
I don't know if your attorney wants you to do that.
Mr.
I was on probation and I've been fighting the same case, the same case over a period of time. I did nothing wrong, and I got my kids back. I got everything going on good for me now. I got my job back and all this stuff, and it's just gonna destroy my life. Because I got I'm staying with my kids now. I'm staying with my baby mama now. The same charge I'm fighting now. I'm saying with the charge they found gummies or what they found some gummies that wasn't my gummies, but it was in the house. What
Well,
was in my
but if
house?
it's, hold on, be careful because you're talking a little too much. You need to argue that with your attorney and argue that in court. But you are responsible if it was your
Gonna
house.
destroy my
But it
life. It's
sounds,
gonna make
I'm
me
not
lose
gonna,
my job, and it's gonna
I'm not-
make me lose everything again.
But you don't come to court. You have a history of not coming back to court. So I can only go by your history for whatever reason.
They didn't let me go back to the old house. They didn't let me go back to the old house. We got evicted out the house. Now we got a new house there that I live in. That's what.
And I bet you've
There's
been
a
there
no
long enough
contact.
to have come down to the court and fix your address.
Yeah,
Or
there's a no
contact your
contact.
attorney.
There's a no contact, and he just admitted to living with the victim. So that
I didn't admit to it. She's right here with me. I stay with her. We stayed with each other.
Right, and there's a
Yeah,
no
but you have a
contact.
no contact order.
We
Be
got our
careful.
kids back. We got our family back, and I got my job.
I think we've gone far enough with that, Mr.
Okay,
Okay,
thank you.
thank you.
Can we do position number 20 and 21 now so I can go take a lunch break?
Yes, ma'am.
Oh, she ready to eat.
Mr. Harvey?
John,
Okay. And what are we doing, Mr. Harvey?
Your Honor, Mr. Harvey, I believe is.
We were resetting him? Oh, they didn't want us to reset. They want us to handle him.
I think he can get through this plea, Your Honor, but I think that he's got a hardship financially, and I know the legislature, I told him, I said, you know, your best chance of getting this, if charges are going to be reduced, so you don't have to do the FVIP, would be good to go on to your trial courtroom and have the lawyers there try to negotiate a different charge. But if he goes ahead with this, Your Honor, he will do his best. If he decides to plead guilty now, he will do his best to get that FVIP done. It is expensive.
Yeah, I don't know how he's gonna do that. State, what say?
John.
Hold on, Mr. Harvey. Hold on.
The cheapest I've seen, Your Honor, and the least expensive I've seen is a very good provider, and the least expensive I've seen on the internet is $35 an hour, and it is 24 classes. You can't skip any, or they'll kick you out and start all over again.
Let's
So
start over, correct?
it runs at least $840, if not $960, if they're charging 40 by now. So
But is he disabled and can't work or what?
he has very limited income. I believe he has physical disabilities galore.
You have any thoughts, ASG Walker?
No, I do not. The offer is what it is. If council has any suggestions on, how he would like his client to resolve, I'm all ears, but
Well, I did notice that all the 4 counts, disorderly conduct was for endangering property, and each count of simple battery family violence was for a different aspect. It sort of broke up an allegation of a situation into 1 slap, 1 grab, and 1,
yeah, they will all merge. It's the same victim.
yeah, that would help, but it would still be family violence, and you'd still have to take the FDIP. So it's gonna be a struggle, but if Mr. Harvey, if you decide to take this plea today, the legislature has said, you're gonna do that FDIP.
Because of the amount of time he's been in, I'll be willing to strike the FDIP and do 6 weeks anger management.
That could really work. That
Okay.
could work. He's been in,
I was gonna say, how many days?
let's see how many days.
48. So it's gonna be 12 months to serve, 96 days, credit for time served, 48. Balance probated, with the conditions of no further contact with the victim, Pearl Styles, the 6-week anger management course, and a stay away from the instant location. And I put the address on the record in just one moment.
I think that would be an excellent solution. Mr. Harvey, do you understand what the state is saying? You wouldn't have to do that FDIP. That was the main problem you had was the FDIP, and we'd have you wouldn't have family violence in the name of what you're pleading guilty to. So is this suitable for you? You would have to go to 6 classes. Wouldn't be nearly as expensive as 24. I think you and your family or friends could come up with enough money to pay for a 6-hour class.
Who is Pearl Styles to him? Who is that?
I have no idea. It's been a long time. That was what, 4 or 5 years ago.
Oh, you don't know who she is? Is it a former girlfriend or something?
I think it may be young.
Oh, okay.
All right, they're not together anymore.
Okay, good.
And that address is 1820 Dunlap Avenue in East Point. And I just want to make clear, he's still pleading to simple battery family violence. It would just merge into 1 count instead of 4.
Okay.
But right.
Well, I have 3.
So
You
I
have to have 4.
misspoke. I misunderstood. So I misspoke. The family violence would still be in there, but we'd be doing an exception to the general rule that is required and do the 6 a.m. instead of the FDIP.
Right.
All right. Do you understand, Mr. Harvey, what we're proposing here as a compromise?
You understand, Mr. Harvey?
I'm gonna have to go to, what kind of class they in now?
Anger management class, it would be 6 1-hour classes, or if you got with, say, Operation 21, you got on the internet. I know you mentioned to me that your sister has a computer. So if you go over to your sister's house and get on the computer and you get with a provider called Operation 21, for example, you could do 4 of the 6 hours on a Saturday morning between 8 and 12. And then you could kill off the other 2 hours the next Saturday or 2 Saturdays from then. The only problem you have would be coming up with a couple $100 to pay for that class.
Okay.
Okay?
Okay, you ready to take your plea?
Yes.
Raise your right hand for me. You affirm the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down. All right, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No.
You satisfied with the services of your attorney?
Yes, Your Honor.
All right, do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, Your Honor.
And you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
You're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
Has anyone told you you're going to receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And if you're presently on probation, it could be affected by a guilty plea today. You understand that?
Your Honor, this charge here was already done before I even got probation. How could that affect probation?
Okay, that's if you are, it's possible. I just have to let you know that, but your attorney's already talked to you about it, okay?
Yes, Sean.
All right, and then do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Sean.
All right, so as to that one count of merging of the simple battery, family violence, how do you plead?
Guilty,
And as to the charge of disorderly conduct, how do you plead?
guilty,
All right, good luck to you. Keep in touch with your attorney so you can get your conditions done, okay?
yes.
All right, take care.
Mr. Walker, can you, what was his, it was still the 96 and 48, or did you, it was?
The time was
Okay.
still the same.
Okay, and the last simple battery is merging with the rest, correct?
Yeah, I think there's three in
Three.
total. So 2 of those simple battery family violences will merge into 1 count.
Oh, so it'll be 2 counts of simple battery family violence
No,
and 1
it'll be-
disorderly.
So it'll be just 1 count disorderly and 1 count simple battery family violence.
Okay,
The 2 additional simple battery family violences merge into the first simple
First,
battery family
to the
violence.
first one.
'Cause there was
Gotcha.
3 in total.
Mhm. Okay. All right, take care, Mr. Harvey, all right? Okay,
Thank you, Your Honor.
all right.
Give me a minute, okay? Your Honor, I have Miss,
Okay, wait a minute, excuse me, 1 second. Michael McCain, I gave you some information and it wasn't accurate. And I need you to change it. Can you hear me?
Well, information exchange about details of your address and that sort of thing, we keep out of the public sphere. And we're in public right now on this Zoom session. But for the
Okay,
purpose.
but I'm not afraid of anything.
No,
Listen,
no. Hold on. I'm going to need you to be quiet, Miss, is it Miss Thomas? Who is that?
Douglas.
Ms. Douglas.
Douglas. Yeah,
Patricia
please be
Douglas.
quiet real quick because we cannot violate some of the competencies. So hold on a second. Do not speak out and say what you're going to say. Hold on.
I can imagine there'd be some variation in some of the information you gave me, but what we've got here, we have enough information, I believe, to go ahead and do pretty much exactly what we had planned to do today. On
Okay,
this.
I'm not trying to be disrespectful, Judge Mincy. I'm not trying to be disrespectful.
Understood.
When can I get with you and get you to change that information in person?
I can come visit you at the ACDC, but I understand they'll be releasing you as soon as possible. So,
Okay, go ahead and do that for me because it's really important that I change that information, although I understand what you're saying. And again, Judge Macy, I'm not trying to be disrespectful, but it's
Okay.
critical that I get this information changed.
Okay. All
Very
right. We understand. And he will come visit you shortly.
Okay,
Before he leaves the jail, okay?
okay, thank you, ma'am.
Okay.
well, she's in a different building.
Oh, that's right. She's down the street.
Yeah, I'll go.
Are you
with her.
going down there or are you just gonna call her?
I believe, Officer Milton can help me, Deputy Milton can help me call her on the phone.
Okay, he'll call you. He'll call there. Cause he's at Rice Street and you're down at Memorial. So,
Okay, when you call me, would I be up in the booth where I was?
That's up to, ACDC.
But you're saying you're going to call me today. Is that right?
Right after court, I'm gonna call you.
Okay.
okay. All right, so what are we doing with Miss Douglas?
That's a plea on 2 cases, Your Honor.
Okay, so we have 22 CR 006497Y, 1 count of criminal trespass, and the 4931Y, 1 count of reckless conduct. Those
Yes.
are the 2 cases we're taking pleas on.
Yes, Your Honor.
All right. State, I don't have the plea here in my notes.
Yes, 1 second, Your Honor. Let me get my notes together. So on
Okay.
condition 11, it's just gonna be 30 days time served, balance suspended, no further violation of Georgia law.
All right,
And then on position 12, it's going to be 12 months to serve, 60 days, credit for time served, 30 days, balance probated with the conditions of a behavioral health evaluation, any necessary treatment, no further contact with Miss Deborah Scott, and a stay away from 764 Cascade Avenue.
All right. That's your understanding, Mr. McLean?
Yes, Your Honor. 764 Cascade is instant location. She'll be staying away from there. She will have no contact with Deputy Scott. She's already doing essentially the treatment that would be in, there's almost no need for evaluation because she's doing the kind of treatment that the BHET could lead to. She's getting the right meds, and when she's on the right meds, it's great. So she intends to stay on that.
All right, stay on her plan of treatment.
Can we inquire who she's getting treatment through or what provider?
10 Park Place, even when.
You could just modify the sentence to say remain compliant with treatment at 10 Park Place.
Right, and that's Grady, and that I was gratified to hear that she was familiar with people there, even when we discussed how to pull this, how to make everything work.
Okay, good. All right, Ms. Douglas, you ready to take your plea?
Yes, I am.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, are you presently under the influence of any unprescribed medication, drugs, or alcohol?
No, ma'am.
You satisfied with the services and representation of your attorney?
Yes, I am.
Okay, you can put your hand down for me. Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, I do.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, I do.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, I do.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No. Well, yes, my lawyer has.
Well, that was in the discussion, you may recall.
Okay.
What the court is really asking you, has anybody promised you the result that we probably expect? And no, there's no guarantee.
No. So no, he did not.
All right, and and has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
All right, do you understand that if you're currently on probation, it's a possibility it could be affected by the guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
Okay, so as to the charge of criminal trespass, how do you plead?
I plead guilty.
And as to the charge of reckless conduct, how do you plead?
I plead guilty.
All right, I will accept your guilty plea to both cases. They will begin processing you, and you understand your conditions. Don't violate any more Georgia laws. You won't be back here. Stay away from Deborah Scott and that Cascade Road address and continue with your treatment at 10 Park Place, and you'll be okay, all right?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you, Ron.
Next, we have Miss Patricia Douglas. I'm sorry, Vicky Thomas.
Okay.
Wait, so you got who? And then we got Lopez. Oh, that's okay, got it. Is that all?
All right, we have 22 CR 0080028H. Vicky Thomas charged at 1 count of reckless conduct, a 2nd count of dog at large, and then the FGA associated with that case. And are these going to be pleas or arraignments, or what do we have?
Yeah, this is going to be a bond hearing. My client pleads not guilty, and we're asking for a reduction of her bond. She has a $4,000 good bond at this point, a surety bond. We're asking for a signature bond, Your Honor. My client, she's been incarcerated for 9 days. She's 45 years old. She's a high school graduate in Florida. She also has a 2-year degree from Florida Community College, where she's in the medical assistance field. She is she is no longer working in that area. She's a temporary, she's looking to work for a temporary agency because she lost her job as a medical assistant, Your Honor, due to this case. She has one adult son. She has a stable address. She's been in Georgia for 25 years. Your Honor, this is a dog at large case, along with a reckless conduct. She has served 9 days in jail, and also, Your Honor, and she's also she's working. Like I said, she's trying to work in the medical assistance field, and we feel that the number of days that she has been incarcerated. And I think if you read her criminal history, Your Honor, there really is not much at all. So we're asking for the time that she spent in jail, that her bond be reduced to a signature bond at this time.
Oh, what is that?
All right.
Oh, okay.
Dave?
Yes, Your Honor. I'm not seeing any bond on the actual case, but
Okay, I'll do that. Okay, thanks.
Yeah, I saw 4,000.
Cool, okay.
Hold on.
so yeah, when I looked up this case, Your Honor, I didn't see any bond posted. I could be confused. But basically this incident happened May 27th of 2021. Mr. James Sanford, who is the victim, left his apartment, which is located at James W. Boone Boulevard, and went to his mailbox. Defendant's dog, a male Welsh Corgi called Rufus, darted out of the defendant's home, her apartment, charged at Mr. James Sanford, bit him on the ankle, and then ran away. The bite was a level 3, and the victim sustained a large laceration from pulling his leg away while the dog's teeth were still in it. Although there weren't any priors with Fulton County Animal Control violations on record, there was a subsequent bite by the same dog, I think within 2 weeks after that. So if there is bond, and if bond is at 4,000, and I think with her failure to appear was specifically for this case, the state believes that it is more than reasonable, Your Honor, considering that this incident happened and then 2 weeks later, another incident with the same victim and the same dog occurred. And I'm not fully aware of Fulton County laws, but I do know after the first, the owner is on notice after the first bite.
Your Honor, the $4,000 bond is because there's a failure to appear. That's where I got the $4,000. That would be position 45. It's position 45 and 46, Your Honor. So it's for the same case, but it's for the failure to appear. They've issued a $4,000 a bond at this time. That's what I've seen. Maybe the solicitor. Maybe she can check, or we can have pretrial services look that up.
Pretrial.
Because that's what I see. I see a $4,000 on the failure to appear, which would be position 45, which is connected to 46.
What was the question again? I'm sorry.
We don't have anything different regarding the bond, and it includes the FTA as well.
That's correct, Your Honor. It's a $4,000 bench warrant.
Yeah, it's just showing a $4,000 bond on the jailing screen. That's it for the FTA.
And the bench warrant, okay.
And,
All right.
and I don't think she has any prior, if you can read her prior history.
No history pretrial?
She's got 2 cycles. First one out of Gwinnett for a DUI, but that's from 2012. And then the second cycle is for the FTA for the case that's on the calendar, but nothing else.
Yeah, so for that reason, I think she needs to get back so she can get her employment. Yes, there might have been 2 bites and I don't know, that's the allegation. My client said that she doesn't believe that happened. So at this point, Your Honor, based on her educational background, the fact that she can work, she's employable. And the fact that she's been in jail for 9 days, Your Honor, we asked for a signature bond.
Where's the dog?
The dog is, that I don't know, but I think she was ordered that the dog be under house arrest or some type of containment in the house, and my client has no problem with that. And maybe the dog has been, I think, taken away. But my
The dog would still have to go to the restroom to have the dog in house arrest. Kind of.
Is it okay, Your Honor, if I say something? I don't want to be disrespectful.
Yeah.
Tell us where the dog is.
The dog is at my home right now. He's in cage. And like I say, like I told Mr. I'm sorry, I'm just nervous. Is that and when animal control did come, the time when he did big by Mr. Sanford, I explained the same thing, that he did run out. He was in the house. I don't ever let him roam freely. Like, I got him from the animal control, not knowing, they weren't honest with me about his history. You know, I thought I was doing a good thing. I'm willing to give him on medication. If I have to give him back, I will. I just don't want to be put to sleep. You know, I love animals. I did it out of love, you know.
But my question is, the dog right now is in your house in the cage?
It's in the house in the cage, yes, ma'am.
But it has to go outside to use the bathroom, so how?
On a leash, on a leash. It's even with my the owner of my complexes. We've already talked to him, and he's always on a leash. Only reason he ran out my door. He's never running around freely, because I know that he can be, you know, he's been, I guess, abused. I don't know his history. I got him from the shelter. But I don't let him walk around freely. He's always on the leash. He only goes out to use the restroom, and then he's inside the house.
That's this incident. But prior to the incident, I guess he was out without a leash. It sounds like.
Okay. I mean, I've never taken him outside without a leash, because you can't. I mean, he can get,
okay.
I mean,
I don't want you to get much more into the details.
ma'am.
Just want to know where the dog is now, so that
in a cage.
any future incidents.
I don't know of any, but the only incident I've had with him, with me, was the incident of him running out the apartment with Mr. James. I gave the dog away to my son's father around, because I felt like I just couldn't handle him, because he pulls, he can get aggressive, you know, and.
Well, let me do this, because I don't want you to make too many more statements regarding your case, because they may not be in your best interest.
Okay.
But what I'm going to do, but I'm going to put some conditions on your release that you must follow.
Yes, ma'am.
I will give you a $4,000 signature bond through the jail. And what I'm going to do is, with that signature bond through the jail, no drugs, alcohol, weapons, or guns while on bond. But with the dog must stay inside in the cage. If not outside, to use the restroom only. I know that might be pretty tough on the dog, but right now you've got to do that to protect yourself as well as the dog. Do you have a yard or something?
No, ma'am. I mean, I do have an area in the front of my complex that I walk him to use it. So that's normally where he goes on a leash.
Okay, so that will be fine. I hope you have bags to pick up stuff like people do. If they do more to keep the community and everything clean, to make sure you have bags to pick up any poop. Make sure you're doing that. And the dog must be on a leash at all times.
Ma'am.
When it's out to use the restroom, and then back into the cage, back inside. If you can't handle and do that, then you need to turn the dog in yourself.
Okay.
To animal control.
Yes, ma'am.
Or to the Humane Society, wherever. So if
Okay.
you don't think you can do this, then go ahead and turn the dog in. But if you can keep the dog with you for a moment. Do not give it to your nephew, your uncle, your relatives, your son's father. The dog is owned by you right now. So do not shift that responsibility to somebody else. And if you can't manage, then turn the dog in.
Yes, ma'am.
All right. And so is there anything else that we need to
On the
address?
bond order, that the The dog had to be in the home unless it's on a leash to use the restroom. That was it.
Correct. And
Right.
not to be given to the custody of anyone else other than herself. She can't
ma'am.
handle it, and the dog needs to be returned to to the animal control or humane society, wherever she got the dog from. If she
Okay.
can't comply with that, because I heard her say she gave it to her son's father. That won't get it.
Well,
And
he
then-
has an open case with this same dog as well, because
Oh, he has a case with the dog too. Oh, well, then maybe both of y'all need to turn the dog in. If y'all can't handle him, because otherwise y'all gonna keep getting cases and be in jail.
Ma'am.
Okay?
Is this 2 and 2?
Ma'am.
It's 2 and 2. Thank you. I was like, what? 2 and 2.
All right, thank you, Your Honor.
Thank you. What do we have left?
Be a little bit.
Or do we have anything left? Ms. Strong, what do we have left?
It's some waiting for 2 probations.
And Your Honor, after these, the 2 probations, we looked them up. They were the add-ons. These cases aren't holding them. Jail staff can't get them here, so we just asked to reset them to Thursday's calendar.
Okay,
Thank you.
so that would be Wilson, number 9 and 10, or Wilson,
Wilson and
5 and 6.
Spencer,
and 5 and 6.
I believe so.
Spencer. All right, so Spencer and Wilson are reset to Thursday.
Thank you, Your Honor. And then we'd also request a reset for positions 27 and 28, so we can have a social worker visit them.
28, 29.
28, 29, excuse me. Just a 1-week reset on that.
Larry Mickle, reset Thursday.
Next Tuesday, Judge.
I'm sorry, next Tuesday. Is that it?
Your Honor, we have Sophia Lopez, I believe, number 26.
All right, and what does that matter? It's one quick thing. I think I know the answer, but I'll just make sure. On Melvin Smiley, on the probation,
Yes,
not the one that we did.
that's the one we did, Your Honor. That's the one where Mr. Ford had the main case and I had the probation matter.
Okay, gotcha. All right. So the only one we have left now is 26. Is that it?
I think so.
Okay. All right, is this a plea?
Yes, it's a plea of guilty negotiated.
All right, 23 CR 0053588F. Sophia Lopez. State.
Yes, Your Honor, the state is asking for 12 months to serve 20 days, credit for time served, 9 days, balance probated, a defensive driving course, and a $300 fine, Your Honor.
Okay. Mr. McLean.
Your Honor, the calculation will result in 1 extra day, which will not harm her because she's got another matter, which would cause her not to be available for release tonight anyway. So the 20 and the 9 still do work for her. She looks forward to performing her obligations on probation.
All right.
Oh, she would like to do 30 hours of community service and instead of the $300 fine, Your Honor.
All right, I'll grant that. All right, Ms. Lopez is where?
We do need to get her on camera. It's gonna be at the ACDC South.
Did they fall off?
No log off.
ACDC?
Well, I see an ACDC jail courts thing there.
Maybe she went to get her.
While we're waiting for that, did we handle position 44?
Thank you, Judge. Yeah.
Oh, that was.
Known as Northside.
Francois, can we call Milton to see what happens?
No, I wrote Charles Ford by it, but I don't think we did. For Mr. Jonathan Tate,
Yeah.
Yeah, we did that. That was the very first one. It's a foresight. From.
oh, that was the Foresight?
Yeah.
I didn't write anything by it either, though.
That was
Oh,
a.
yeah, we did.
What do you have, Ms. Strong?
We did. All we did was just waive arraignment, that's all.
We didn't. I don't think we did.
I have reset jail jury.
Yes,
Oh.
Yeah,
that's exactly right.
right, we just waived his arraignment. He was in the room.
Oh, we did an arraignment. Okay. See any others, Nimini?
Okay, so while we're waiting, can we go ahead and go through the calendar since you have to get off? Since you have another court to do now?
Yeah.
Position number 1 was a negotiated plea. Position number 2 was null pros. Position number 3 was a negotiated plea. Position number 4 was a nolo plea. Position number 5 was null pros. Position number 6 was a negotiated plea. Position number 7 was an amended bond, $3,000 signature bond through the jail. Position number 8 was a negotiated plea. 9 was a negotiated plea. Position number 10 was a nolo plea. Position number 11 and 12 were negotiated pleas. Position number 13 was a negotiated plea. Position number 14 was an amended bond, $2,000 signature bond through the jail. Position number 15 and 16 negotiated plea. Position number 17 was reset jail jury. Position number 18 was arraigned reset jail jury. 19 reset jail jury. Position number 20 was a negotiated plea. Position number 21 was null pros. Position number 22 was reset jail jury. Position 23 negotiated plea. Position number 24 was arraigned reset jail jury. Position number 25 was arraigned reset jail jury. Number 26 was a negotiated plea. Position number 27 was arraigned reset jail jury. Position number 28 will be reset for Thursday's SAP calendar. Oh, excuse me, I'm sorry, Tuesday's SAP calendar to speak with a social worker. Position number 29 was reset for Tuesday's calendar as well. Position number 30 was a negotiated plea. Position number 31 was an amended bond, $4,000 signature bond through a pretrial per judge. Position number 32 was arraigned reset jail jury. Position number 33 was a non-negotiated plea. Position number 34 was a negotiated plea. Position 35 was a non-negotiated plea. Position number 36 was an amended bond, $3,000 signature bond through the jail. 37 was an amended bond, $3,000 signature bond through the jail. Position 38 was a negotiated plea. Position 39 was null pros. What happened to position number 40?
You already, that's a 1 week reset request. Have a social worker speak with Mr. Sims as well.
All right. This next Tuesday.
Yes, ma'am. Position number 41 was a negotiated plea. Position 42 was null pros. Position number 43 is reset to Thursday's SAP calendar to accompany the other case. Position number 4 was reset jail jury. Position number 45 was null pros. Position number 46, I'm sorry, it was not null. Well,
I know, right? No,
well,
still there, even though I just gave her a bond.
right, so I'm not
But
sure.
that was only if she pled guilty with the no bond.
No, this was an amended bond, so are you dismissing the FTA Judge Mincy, or what would you like them to do with the?
I see Ms. Nimini shaking her head. Normally we don't if they don't take a plea, correct?
But the FTA will hold her in, she
Right.
won't get out.
That's what the amended bond order is for, so I'm not, what was the bond amended to, a signature bond?
Yes.
So, bond amendment needs to be presented on the FTA.
What now?
So that's not what they addressed it as, Mr. Walker. They addressed it as in the actual case, not the FTA. So that's what,
They just need to put the FTA
they on
number.
the, I mean, yeah. I just want to make sure that they do the bond order correct, because if
Correct.
it's gonna come back to me and I'm gonna have to send it back again.
Right,
Oh, you're right. They need to put the FTA number on the bond order.
okay.
Is that what we want to put the FTA number on the bond order? All right,
Yes,
along with the current case number 2?
they put both.
Both? Okay.
$47.
It's an amended bond, $2,000 good bond. And the DV bench warrant case, the defendant is to turn himself into the Fulton County Jail by 1:30 tomorrow afternoon.
Mm-hmm. And then your
Also,
probation.
Mr. Jordan is asked, I didn't do that, Judge. But Mr. Jordan was asking if we're done. I'm not sure where the jail is with Ms. Lopez, but it's 2:13, so he's inquiring about the C calendar.
Okay, tell them I'm coming. Give me a 5-minute break in between and then I'll sign on.
Did they want to bring her in during the C calendar? I come back, but now we're holding for just that person, so.
I don't know if they can get her.
That's all.
Can I inquire, what was the announcement? Was it gonna be a plea or?
It was supposed to be a plea. Did we need to reset her for Thursday as well?
26.
Probably do that.
Is this a time thing? She's got.
They haven't been able to get her since 9 a.m.
I know, right?
And yeah, if we can reset to Thursday, I think, my understanding is this isn't what's holding her.
Okay, great.
One of the things, right?
That's which one? That's number
26, that's just the two days.
26.
That's
Okay.
fine. That works.
All right, we'll reset her Thursday. Okay. All right, I'm signing off. Thank you, everyone.
Bye-bye.
Thank you.
Bye-bye. Bye.
Thank you.